You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Merc versus the state of Florida.
May it please the court. My name is James Vigiano and I represent Mr. Merc. I'd like to argue issue number 5 of the initial brief. Trial counsel was ineffective in failing to present mental health mitigation at Mr. Merc's penalty phase. With respect to the remaining issues, I would rely on the briefs.
Could you set the stage about this? Was this a second or third penalty phase?
There was Merc 1, it's a penalty phase 2 there, Merc 2, another penalty phase, and this was the third penalty phase.
And the lawyer that handled the third penalty phase, was that the lawyer that handled the first and second penalty phase?
No, Your Honor. There were different lawyers. The PDs were appointed on the third one. Mr. Watts got appointed after a conflict with the public defenders, and then Mr. Watts brought in Mr. Schwartzberg later on in the representation because of the workload.
Now, I guess what I want to know is that when something gets tried 1, 2, or 3 times, there was mental health mitigation in
the second one.
The second one. So what about the argument that, and what was the jury verdict in that second one?
The second one was a 12-0.
So with mental health mitigation?
Yes, but there was not a psychiatrist presented.
But I guess the question is, don't we, when looking at the totality, we have some advantage of seeing, well, if you try this tactic, this didn't work. Did that figure into this lawyer's decision to not call a mental health expert in penalty phase number 3?
We don't know what factored into Mr. Schwartzberg's decision, because if you look at the totality of the circumstances, he didn't look into much of anything. He made an uninformed decision not to present Dr. Mayer as the mental health expert in the third case in which he handled. This can be seen by the totality of the circumstances.
Well, didn't he testify, Mr. Schwartzberg?
Mr. Schwartzberg died about a year after this trial. This was his last trial.
Well, I thought there was something in the record about the fact that Mr. Schwartzberg took the position that he didn't want to call Dr. Mayer out of fear that I would open the door to this Dr. Sloman to say things that he did not want to say.
I think what the court's referring to is 11 days after the penalty phase, there was a Spencer hearing, and as an afterthought, Mr. Schwartzberg was trying to explain himself to the court. He was trying to explain himself because when he abdicated his responsibility to present Dr. Mayer at the penalty phase, it caught the court, Dr. Mayer, and co-counsel completely by surprise. They were shocked. They had to stop the trial, take a recess, and have a colloquy. So then 11 days later, at the Spencer hearing, Mr. Schwartzberg, as an afterthought, tried to explain himself. And he said to the court the reason why he did that was because he was concerned if he called Dr. Mayer, Dr. Sloman would confuse the jury about the term of sentence that Mr. Merc might serve. Now, Dr. Sloman did not talk about any term of sentence. And additionally, Dr. Sloman was going to testify simply as to antisocial personality disorder. That's all he was going to say. He was a psychologist, not a psychiatrist like Dr. Mayer. Dr. Mayer had a very detailed diagnosis, an Axis 1 diagnosis of brain damage, fetal alcohol effect, ptosis, which was related to neurological problems that he suffered in utero, post-traumatic stress, attention deficit disorder. Now that both experts relied on the same basis for their opinion, Sloman was going to say it was antisocial personality disorder. Antisocial personality disorder is a description of behavior, not an explanation of cause. Dr. Mayer would have testified as to the diagnosis, an Axis 1 diagnosis, whereas Dr. Sloman was just going to describe the behavior.
Well, and you're doing a very good job of explaining this, but let's go back to what Schwartzberg either reasonably could have decided. Schwartzberg comes in to do the penalty phase?
The way they divided it was Watts would handle the lay witnesses. Schwartzberg was going to handle the expert witnesses and the cross-examination of the state's witnesses.
In the penalty phase.
Only a penalty phase. Watts presented his end. He laid out the foundation, the dysfunctional upbringing that Mr. Merc suffered, and all the portions about his mother trying to abort him by drinking excessive amounts of alcohol, drinking turpentine, jumping off a porch, getting into fights, all in an effort to abort him. She didn't want her husband, who was in Vietnam, to know that she became pregnant while he was over there. She tried to abort it.
You're going in a lot. I'm trying to find out about the deficiency prong. How long did Schwartzberg have to prepare for the penalty phase?
He came on very late in the penalty phase, and Dr. Mayer called him numerous times, made several short phone calls to set up a meeting with him. He billed him only for 2 15-minute calls where Dr. Mayer implored Schwartzberg to meet with him.
So this is not a situation where Mayer said, don't put me on because this will be harmful to you.
Absolutely not.
What did co-counsel, did co-counsel think that Mayer was going to be called?
Apparently yes, because he testified he was shocked. It came in at the 11th hour. Schwartzberg, after Mr. Watts put his lay witnesses on, Schwartzberg announced they were going to streamline the trial. It came as a surprise.
And did Watts testify at the evidentiary hearing?
Yes, he did.
And he said there was no strategic reason for not calling Mayer?
He said he was surprised and miffed that at the 11th hour that they weren't going to present Dr. Mayer. He said he thought there was some reason for it, but he couldn't recall what it was.
Was there a problem or was there an issue with regard to conflict between the position in the guilt phase and what the testimony may have been from this expert? Any issues with regard to that about whether Merc had committed this act or whether he had admitted that he had done the act, and whether there's any issue with regard to whether Mr. Merc himself had said that he just that he went above and beyond anything that he thought possible? Is there anything like that that ought to be factored into the totality that we're talking about?
Well, the facts that were presented at the penalty phase were the facts that were presented at the guilt phase. They were presented at the penalty phases that previously put on. The same facts were put on at this penalty phase. So the jury knew what happened out there.
It's a very simple, straightforward question. Were there any issues or disputes with regard to what this expert would have testified to that would have impacted something about how the underlying events, the guilt of the guilt phase of this event?
There wouldn't have been any
nothing at all.
Any guilt phase issues. Now,
say guilt phase issues. Please understand. Let me go back and make sure we're communicating. Were there any issues with regard to a lawyer making a decision to call this witness that were impacted by things that Merc may have said to him with regard to his guilt and what he had done that should be factored into our discussion or analysis?
Well, at the 92 deposition, Dr. Mayer testified that Merc said to him that he was excessive in what he did. So he admitted to Dr. Mayer earlier on at the initial interviews.
And he admitted that he did it.
He admitted he did it.
He admitted he did it, and that he went beyond what was necessary to protect himself. Or something.
That's what Dr.
So that's something that should be factored into our discussion and analysis.
It's not necessarily factored into Schwartzberg's thought pattern, because consider this. He didn't mention that, and also that the jury had already convicted him at the guilt phase. The jury had already heard all of the evidence presented at his penalty phase, the same evidence. So the jury already heard all of this. They heard the facts of the case. And the issue, whether Mr. Merc admitted to it or not, was not an issue at all.
Who is Dr. Miller?
Miller?
Is it Mayer or Miller?
Mayer. Dr. Mayer. Dr. Mayer was the doctor who was retained in the early trial.
But is there a Dr. Miller?
There was a Dr. Heidi who testified. Marin, I think maybe Marin, referring to. Dr. Marin was one of the state's experts early on.
Dr. Miller in the next case, so it's all right.
Let me ask you this, because I believe Mr. Watts testified that when the Spencer hearing came about, that he was handed the file at the last minute by Mr. Schwartzberg.
Right.
And I think he testified that he was perturbed by the last-minute change and felt unprepared to examine Dr. Mayer during the Spencer hearing.
Correct.
Also felt that he was shocked by the lack of communications between Mr. Schwartzberg and Dr. Mayer throughout the entire proceedings.
Correct.
Was there something wrong health-wise with Mr. Schwartzberg? It seems like either he lost interest in the case or something was going on. You said he died?
That's right.
Was that soon after the trial? Or?
After the trial. This was the last trial he tried.
Was he ill for a long, extended period of time?
He was ill. He had done capital trials. He had worked with Watts. He had worked with Mayer. But he had a heart attack. He had a heart attack. He had gastrointestinal problems, which required surgery. He was having marital problems, marital discord with his wife. She had spending issues, according to Mr. Watts. Mr. Watts said that he thought maybe his wife was mentally ill. They were having literally custody battles over their dogs. And Mr.
This
Watts...
is going on when? In relation to the...
Mr. Merc's trial. During Mr. Merc's trial, this was all going on. Both the attorney Watts, the attorney he worked with in the past many times, and Dr. Mayer, who Schwartzberg worked with, said this was unusual behavior for Mr. Schwartzberg. Dr. Mayer said that although Schwartzberg was good on the generalities, he was weak on details, and that's the reason I wanted to get with him on the mental health issues. But this was unusual behavior for Mr. Schwartzberg. Both the attorney and the expert testified to that. And in fact, that was the last trial that he ever tried because of all these health problems and marital problems he was having, and died shortly thereafter.
Despite the failure of Mr. Schwartzberg to communicate with Dr. Mayer, is there any question here as to whether or not Dr. Mayer had been given other documents involving this defendant? Did he have the school records? Did he have any other health or mental health records? Did he have prison records? Whatever. Did he have those kinds of information that would be helpful in him doing his assessment?
Dr. Mayer obtained all of his materials from the public defender's office after he had worked the case up early on in '92. He got nothing from Schwartzberg. Everything came from the public defender's office.
So did he testify in the prior penalty phases?
No, he did not. That one ended in a mistrial. He never testified in any of the prior penalty phases. But he had examined this defendant prior to all of those penalty phases. Yes, Your Honor.
And so why wasn't he used in any of those other penalty phases?
Well, he worked it up before the mistrial, and he just never testified there. And then none of the other lawyers who proceeded thereafter used him or contacted him. He got the material. He worked up the case, and in the '92 deposition, he had that detailed diagnosis involving the ptosis, the neurological problems, the post-traumatic stress disorder, the ADD, the brain damage, the fetal alcohol effect. He had all of that.
So with all of that being said, what is it that he would have contributed to this penalty phase? Would he have demonstrated the statutory mental mitigators, or would there have been some non-statutory mental mitigation? What is it that you believe a jury should have heard that would have possibly made a difference? I know this was a 9-3 determination by the jury.
He would have tied up the mitigation because the jury had heard horrible anecdotal evidence of Mr. Merck's background, it just hanging out there. Dr. Mayer would have tied it up. He would have lent context to that testimony.
In what respect? I mean, that sounds
brought out the violent history of this defendant?
The history, the violence was already brought out through the aggravators. The state brought out 5 aggravators, and they were already brought out. And any other aggravator, any other violence or anything, the state was going to stay away from it. There was an act of violence that he committed while young, caused Merc 1. And in fact, when the Spencer hearing went on, Dr. Mayer testified. It never got brought out in his testimony or on cross-examination. Surely the state didn't want to elicit that and cause another mistrial.
Well, let's see if we can just tie this up here. The trial judge found that Mr. Merck had this difficult childhood, that there was alcohol abuse and maybe alcohol dependency here. And so how would Dr. Mayer's testimony tied all of this together?
Well, with Dr. Merck's testimony, the defense could have presented the instruction of extreme mental emotional disturbance at the time of the offense. Based upon the alcoholism, the brain damage, the fetal alcohol effect, which results in a neurological problem. He had ptosis in his...
So, I mean, we always hear about all of these things, and so he was prepared. You're saying Dr. Mayer was prepared to say, because he had all of these things, that gave him mental and emotional disturbance at the time that this crime took place? Absolutely, Your Honor. Then the jury can determine Mr. Merck's moral culpability, and basically they'd also get an instruction capacity to appreciate the capacity of his criminality. They'd also have that. As is, the jury just had this... So because he had all of these conditions, you're saying that at the time that he had this confrontation, this is the case where he was at a car and
a bar fight.
Was talking to this guy, and then went back to his car and got a knife, I believe it is, and stabbed this person to death. So you're saying that because he had these static kind of conditions, he, at the time that he went and got this knife from the car and confronted this, I believe, unarmed victim, that he was suffering from a mental and emotional distress. Absolutely, Your Honor, absolutely. And also, Mr. Schwartzberg also abandoned presenting a toxicologist who would testify as to a .16 and a .26. No explanation for that.
You're way into your rebuttal, but I have to ask the question I started with and make sure I understand. In the second penalty phase, there was mental health mitigation, and the trial court found the statutory mitigator for extreme emotional distress during the second penalty phase. The jury, it was 12-0 against Mr. Merc, right?
Yes.
So even if we find deficiency, I'm still having trouble, and maybe you'll just address it on rebuttal, how, when it was presented, the jury was not only unmoved, but actually found 12-0 against Mr. Merc.
The expert that testified at that penalty phase did not testify as to the diagnosis that Dr. Merc had or Dr. Mayer would have had in the third penalty phase. I'm way into my rebuttal.
May it please the Court, Assistant Attorney General Stephen Ake on behalf of the State of Florida. I'd like to clear up a little factual thing there, that if I understood counsel's argument correctly, he was saying that Attorney Watts testified that he was shocked and miffed that they didn't present Dr. Mayer to the jury. And I don't think that's his testimony at all. I think what he said he was shocked and miffed at was the fact that co-counsel gave him Dr. Mayer at the Spencer hearing, and he wasn't really prepared for that. That's what he was shocked and miffed at.
What did he say about co-counsel about... Was he at all surprised? Did he assume Dr. Mayer was going to be testifying before the jury at the penalty phase?
Your Honor, Richard Watts testified that they had taken Dr. Mayer's deposition in October of the year prior to the penalty phase. The penalty phase was in March, I believe, of 04. And in October of 03, Schwartzberg had taken Dr. Mayer's deposition. And Richard Watts testified that they had made a decision after that time that they didn't think they were going to put him on to the jury. He couldn't recall the details of why they did that, but then...
Let me just make sure. The defense lawyer who has Mayer as his expert took his deposition?
Well, the state took his deposition. He was there. He was attending it.
I thought that there isn't testimony from Dr. Mayer how he kept on trying to call Mr. Schwartzberg, never got a call back, was getting increasingly concerned because he had found that Schwartzberg previously had always been a very good lawyer to work with, and this time he didn't understand why he wasn't getting calls back.
Dr. Mayer did testify to that regard, that he had tried to contact him numerous times.
So the co-counsel actually, instead of being shocked and surprised, he testified that together he and Mr. Schwartzberg made a strategic decision not to call Dr. Mayer?
Right. He said that they had made some decision, but he just could not recall, given the passage of time, what that decision was. And obviously we didn't have Mr. Schwartzberg there.
Well, wait, the decision was obviously, when he said he doesn't recall the decision, must have been not to call Dr. Mayer.
Correct. And I believe they made that decision at the time of the deposition in October.
You believe that based on what?
Dr. Richard Watts' testimony, that they took his deposition, decided not to...
So if we read, is his deposition in the record?
Yes.
And I want to understand something. They didn't want his deposition they didn't want his testimony because Mr. Merc confessed that he killed the guy?
Correct.
Well, but the jury was already going to hear. He had been convicted. This was only a penalty phase. What evidence would have come out when Dr. Mayer testified that the jury wouldn't have heard about him being violent? What was it?
Well, I think what they were concerned with...
What was it that they were really worried about coming out? Trying to understand.
Well, what they stated on the record at the time was they were concerned with the state calling their rebuttal witness, Dr. Sloman.
To say what?
Dr. Sloman was going to diagnose Merc with antisocial personality disorder.
But I understand these are all these words, just like Justice Quince is saying. Somebody says it's extreme emotional distress. Someone else says it's, prior violent felony. You got kind of an impulsive act here of somebody that, for a ridiculous reason, ends up killing this poor innocent victim. So the jury's looking to say, well, what happened? Did something snap? What was it that, as far as his prior life, that would have come out through Dr. Mayer that the jury wasn't going to hear otherwise?
Well, I don't know that necessarily Dr. Mayer would have testified, although he did say that he met the criteria of antisocial personality. I think more Dr. Sloman would have testified as to more of the negative stuff, as to his prior outburst of violence.
When I'm asking about the outbursts, maybe did the jury not hear that? These were things that the jury would not otherwise have heard?
The jury was aware that he had been convicted of these offenses, but did not know the details of the offenses.
Well, I guess the thing is that if I'm a juror listening to somebody who has an outburst of violence, and I either find that that person has never acted that way, or I now find out he has other prior violent felonies, so I go, this guy is a violent guy. I now am looking for an explanation. If an explanation is that Dr. Mayer was prepared to testify that he had brain injury, that he had fetal alcohol effect, that he had ptosis, PTSD, it gives then an explanation for why somebody would, unprovoked, commit a violent act, wouldn't it?
Certainly, but you also have to factor in that Dr. Sloman is going to get right up to the jury and tell him that he doesn't have brain damage.
Well, is it true that Dr. Mayer is a psychiatrist?
Yes.
And what's Dr. Sloman?
Psychologist.
All right. I really don't know how a psychologist can testify. I think we have cases that maybe they do in death cases, but can't testify to organic brain.
Well, what he was going to...
They're psychologists. So you're saying the strategic decision was we don't want Dr. Sloman to testify.
That's what they said on the record, Your Honor.
The record at the time of the Spencer hearing?
Yes. At the time of the penalty phase, there's a colloquy because the judge realizes they've announced that they think they're only going to call one more witness, being the defendant himself, Merc. And the judge realizes, well, you know, we got Dr. Mayer here in the courtroom. Dr. Sloman's here, apparently. The state wanted to know if they were going to call Dr. Mayer, so they took a recess to let him talk about it. They made a record right then and there. Merc acknowledged that he knew they weren't going to call Dr. Mayer in front of the jury. That was all done on the record. And then, 10 days later or whatever at the Spencer hearing, Mr. Schwartzberg says, the reason why we didn't do that is we didn't want Dr. Sloman coming in here and testifying. So it's all on the record as to why he did it.
It really kind of goes back to what is it that was so devastating about what Dr. Sloman would have said that would have caused them to make this kind of decision? What is it specifically
that
Dr. Sloman was going to say?
I think he was going to detail his prior crime in detail as to what all he had done. He was going to testify that he's actually had his IQ has actually gone up while he's been incarcerated from, I think it was a 110 to a 122, I think it was, and that would negate any kind of allegation that he has brain damage because he's actually gotten much smarter while incarcerated. So, I think defense counsel was worried, what is this jury going to hear, and is it going to negatively impact Dr. Mayer's testimony to him? And counsel was aware that mental mitigation had been presented at the earlier penalty phase where it was 12-0. So, I think they're just taking a different strategic tactic here and saying we're going to present it at the Spencer hearing and not let the jury hear, but we'll let the judge hear it at the Spencer hearing. That happens all the time. They teach that in the seminars.
And that's always been of interest to me, why defense attorneys do just present the mental mitigation at the Spencer hearing as opposed to before,
Well, I can tell you, Your Honor, that they teach that life over death seminars, that the reason to do that is you go into the penalty phase with the jury, you get a vote, and say you get a vote of 7-5. Then you come back at the Spencer hearing and say, Judge, here's all this mental mitigation that the jury never heard, so I want you to override that jury recommendation. And that's a strategy that is being taught to the defense attorneys.
But you understand, and you're here obviously advocating for the state. There may be some cases, and we've seen them, where the type of evidence that would come out, where they're trying to sort of paint the person as this nice guy and all that, and now you're going to get a different picture. But that's not this case, and I think my concern is really about whether we had an attorney that was on the verge of either some type of breakdown or wasn't playing at his game, and we got a death case. So maybe the better thing would be, let's address the prejudice part, because I'm a little concerned about the deficiency, but on prejudice, I'd like to hear your argument as to why it shouldn't undermine our confidence in the outcome.
Well, one, Your Honor, is that all this was presented to the judge at the Spencer hearing. Dr. Mayer and Dr. Sloman testified. The trial judge heard all this that sentenced Merc to death, and he rejected the two statutory mental mitigators in this case based on, one, the facts of the case, and two, Dr. Sloman's testimony in this case. And based on that, I think the jury would have done the same thing based on hearing Dr. Sloman and Dr. Mayer's opinion. So I don't think you can say that he was prejudiced, because both the trial judge and this court on review had that information in front of them as to Dr. Mayer's opinions. He didn't offer anything new in post-conviction. It's the same opinions that they had back in 1992 and later on in 2003 when they took his deposition. Now, Mr. Schwartzberg had those depositions. Dr. Mayer had been on this case since day one. So he had given two depositions in this case, and Schwartzberg had that information. He knew that Dr. Mayer had everything he needed to form his opinions. It wasn't a case of him making an uninformed decision not to call him. This was an informed decision not to call him. And then, as the trial judge found when denying the motion, they can't show prejudice in this case because
Is the question for us whether or not that decision that he made was a reasonable one under the circumstances of this case. And so what we end up with, it seems, is that we have a defendant who may or may not have organic brain problems, but the jury never got to make the evaluation based on having heard Dr. Mayer and then possibly having heard Dr. Sloat.
Right, but I think that, again, is a classic strategic decision that trial counsel has to make in the heat of the moment as to, he had Dr. Mayer there. They could have presented him to the jury, but they talked about it. They conferred during the recess and made that ultimate decision that, no, we're going to call him at the Spencer hearing instead.
Was Dr. Mayer prepared to, see, I guess I'm still having trouble with this idea that there wasn't, that Dr. Mayer had to keep on calling Mr. Schwartzberg, and we don't have Schwartzberg's testimony, so it's like you're piecing this together. But I think your strongest argument is really that if the judge heard it and we have the testimony and it's not really that compelling, then that probably is the way to go on this. I'm looking at the actual direct appeal case, and it was a 4-3 because some of us thought the penalty phase arguments were, really tainted the penalty phase. Is there any argument in this case about whether trial counsel should have objected to some of these penalty phase arguments?
No, Your Honor, that was never an issue in their post-conviction pleading. I wanted to kind of correct this court's misunderstanding as to the health of Mr. Schwartzberg. There was vague testimony, and it was very vague as to the timing of this, as to his health problems, that he definitely had gastric bypass surgery and had a heart attack at some point, and it's not clear, even Mr. Watts couldn't recall when it was in conjunction with this case. But I think Dr. Mayer has a problem with his involvement with Schwartzberg, but I would imagine that Mr. Schwartzberg was well aware of Dr. Mayer's calling him and knew what Dr. Mayer had to offer. So I don't think it's a case of Schwartzberg ignoring, Dr. Mayer necessarily, as he knew what he was going to say. He knew his opinions. He had everything available to him. If he wanted to use him, he would talk to him and use him. And they did talk. They had a couple phone conversations prior to the penalty phase. So I don't think this is a case of Mr. Schwartzberg abandoning his duties as they've alleged.
So Mr. Mayer, in a timeline, Dr. Mayer had already examined this defendant prior to Mr. Schwartzberg ever getting on this case.
Correct.
Right?
He'd been on since day one. So he examined him back in 92, I think it was.
So his reports and these depositions, one deposition was taken of him prior to Mr. Schwartzberg being on the case, and another one was taken that Mr. Schwartzberg actually attended.
Correct, Your Honor. Yes. If there are no further questions, I'd ask this court to affirm. Thank you.
Rebuttal. I'd just like to point out that on the Merc 2, the expert that testified at that was a criminologist. Dr. Heidi was a criminologist, so it wasn't a psychiatrist, medical doctor who could testify as to Axis 1 diagnosis.
What about the argument that the judge heard it, we have that, and the judge did not find that to be compelling mitigation, as far as not that is evaluating that it's really not strong mitigation that would have changed or undermined the outcome of the penalty phase.
The argument is that it didn't get before the jury. The jury didn't
I understand that, but it's not. But a judge heard it and evaluated it and didn't find it to be compelling mitigation. Is that worth anything in our looking at sufficiency?
Well, Judge Downey saw that it didn't find that the mitigators were established. He had to give great weight to the jury recommendation, and he was in a position to override. So that was the prejudice to Mr. Merc at that point. Additionally,
Dr. Mayer had never been used as a witness in the case in any of the prior trials?
That is correct, Your Honor.
Was there any discussion or any reason given for that?
No, Your Honor. That was the shocking thing. Dr. Mayer was in the courtroom.
No, I mean before. Because I think Justice Quince asked the question earlier and didn't quite get an answer, but this expert did not testify in any of the prior proceedings and was on board from the outset. Well, so it had not been called through, three? This makes the third time?
Correct, Your Honor. Now, the first attorneys that retained him, that case ended in a mistrial, and then new attorneys came.
That point. Okay.
Then new attorneys came on. And I'd like to point out the 2003 deposition that Mr. Schwartzberg attended. Ptosis was not mentioned in the deposition. Brain damage, attention deficit disorder, fetal alcohol syndrome, post-traumatic stress disorder was not mentioned in the deposition.
But in that deposition, didn't they refer back to the deposition in 1992, asking if anything changed since that time?
Yes, Your Honor. They asked one question. They said, have your opinions changed since 1992? The answer was no. Then they moved on to adaptability in prison, and they talked about that for the remainder of the deposition. So the diagnosis was not fleshed out. Schwartzberg didn't ask any questions. Schwartzberg never knew Dr. Mayer's deposition, or his opinion. He never knew of his opinion either through the deposition or talking to him.
And why not? Is there clear record evidence that he never reviewed the 1992 deposition?
There's no evidence that he reviewed it.
Is there evidence that he did not? That's what the question was.
There's no. It was not mentioned by him. He never mentioned it. No one mentioned it. His partner couldn't address it. His partner said, "I was surprised and shocked when he abandoned this. It was a shock to me also." He was miffed and upset at the 11th hour after they had Dr. Mayer in the courtroom, and Mr. Watts lays the foundation for his partner to put Dr. Mayer on, and he shuts down.
I don't think that really answers Justice Lewis's question is, what evidence do you have that Mr. Schwartzberg was not familiar with the earlier deposition that was taken of Dr. Mayer?
All we can refer to is the totality of the circumstances because Mr. Schwartzberg's dead and he can't answer that question.
So you have no evidence that he did not familiar with that.
He didn't raise it. He didn't address it. We don't know, but everything surrounding looks like he was not prepared. With that, I'm out of time. Thank you.
Thank you. We thank you both for your arguments.
Excuse me.
We now move to the second case on our docket today, Chalito versus the state of Florida.
May it please the Court, Linda McDermott on behalf of Michael Chalito. I also would like to argue the ineffective assistance of counsel at penalty phase claim.
And you do have Dr. Miller, right?
Yes.
Okay.
Doctor, I kind of wanted to stand up, but thought that would be inappropriate. So, starting with the deficient performance prong, I wanted to establish a few things. There was one attorney in this case, Rafik Eller. There's no second chair. This is a trial and a penalty phase. The timeline is that from the indictment and the appointment of Eller until the trial, there's less than 5 months. In mid-April, Eller asks for a competency and sanity evaluation, and this is when Dr. Miller gets appointed. He does that. He conducts a competency and sanity evaluation only. He provides that report in about mid-April to Mr. Eller.
The attorney didn't ask him to also look at mitigation?
No. On June 26th, which is about 3 weeks before trial, Eller has a conference with Mr. and Mrs. Chalito, at which time he learns that Mr. Chalito has had some previous institutionalizations for mental health issues. He has a list of names of places that he's been institutionalized in Jacksonville, and on June 28th, he drafts some requests to various institutions asking for the records. On June 28th, he gets a response back from the Grant Center, and they tell him, you haven't provided us with a release, and we also need a $50 prepayment. So that's on June 28th. Everyone else also has problems with the way that he's asked for the records because he hasn't supplied a release for the confidential records. On June 30th...
But he, in fact, got the records.
No, he didn't get the records.
What record didn't he get?
He didn't get any of the records in June.
I didn't say in June, but did he get those records that he had asked for?
He never gets the grant records. He gets other records within a day or 2 days before.
It wasn't the grant records that he said that he read all 234 pages of it?
No, I think those are the charter records. Mr. Chalito had been institutionalized in 1990, again in 1991, where there was a full workup of his neuropsychological conditions, and then again after that, when he had a suicide attempt, he was then institutionalized again.
This is somewhat unique, because Mr. Chalito was how old at the time of his crime?
Mr. Chalito was 18.
So his hospitalizations for mental issues occurred at what ages?
His first one, I believe, was when he was 14 years old. He was admitted to charter based on some problems he was having in schools. I don't know if he had a juvenile.
And how long was he in that institution?
In that institution, he was in charter for, the mother testified he was in there for about 47 days, but I think it was closer to a month or so. He was in charter. And every time he went in, they recommended further treatment, residential treatment, and because of the costs, he was never placed in that treatment because the insurance would run out, or he couldn't come up with the costs for the treatment.
Was the discharge summary from Grant placed into evidence?
Yes.
They did get the discharge summary at some point.
They did get
no other records?
What had happened...
no other grant records?
Right, no other grant records.
Just got the discharge summary.
Yes, because it was included... At Grant, he was prescribed Tegretol. Mm-hmm. And because he was prescribed that, and then he was referred to Dr. Alvarez Mullen, that particular record was included in his records.
But now that's
which were received.
The one that indicated the organic brain damage and the extended problems?
Right. When he was at Grant, he had a full workup. So he had, he saw a physician, he saw a nutritionist, he saw a neuropsychologist, he saw a family counselor, and he saw a psychiatrist. So this was the first time he had ever taken any neuropsychological testing. Previously, he'd had some personality testing, and he had had IQ testing. But this was the first time that they did the EEG of his brain and that they did the neuropsychological testing. So this was the first time that they had determined that the problems he was having are related to the organic brain damage. So just going back to the timeline, Eller's aware of these records in June. On June 30th, he asks the court to give him a recess between his guilt and penalty phase, and he says he can't adequately prepare for his penalty phase while he's working on his guilt phase. And he also cites to another case that he's got going on. Trial starts in July 17th. The verdict comes back July 21st. Mr. Chalito was found guilty. Then between July 21st and August 10th, the only activity on Mr. Eller's timesheet is he prepares a motion for new trial on July 31st that takes 2.5 hours. On August 10th, 8 days before the scheduled commencement of the penalty phase, he starts to attempt to obtain releases from Mr. Chalito to go get these mental health records. On August 15th, he gets the Navy records, and he gets the Dr. Alvarez Mullen's records. He has a conference with Dr. Miller on August 16th. He faxes him one page from Grant and asks him if he has anything that he could offer in mitigation. Dr. Miller says no. There was never a mitigation evaluation in this case. And I would just point out, like Arbelayez and Ponticelli, when you've got indications of a mental health history and you don't have a full mental health workup for mitigation, I think this court has said that that is deficient performance.
Well, do we take, this is what I want to make sure about, because in every case, probably now, lawyers would say, let's get a mental health expert. Is what makes this different that he had this extensive psychiatric, psychological history, legitimately so, before the crime occurred, that really needs to put defense lawyer on notice? In other words, that's different to me than, say, Mr. Chalito is 50 years old and never had anything, but you want to get a mental health expert. So could you kind of customize it to this case? Why is it so glaring in this case, even back whenever this trial initially occurred?
Sure. I mean, I think you've just sort of stated the point. I mean, you have records coming in. You're getting bits and pieces saying that your client has organic brain damage, that he's been placed on heavy narcotics, he was treated with Prozac as a teenager, that he has a suicide attempt. I mean, these are things that the alarm bells should be ringing.
And what's going on with his school records? Did they get the school records?
He did. He got the school records, again, the day before, 2 days before the beginning of the penalty phase. He picked up the Charter, the Baptist, and the Duval County School Board records. The school records are equally filtered with just horrific sort of anecdotes about this child and the problems he's having. I mean, when he enters kindergarten, he's eating glue and pencils and paper, and the teacher says, he was malnourished. There's no doubt about it. And she testified at our evidentiary hearing as kindergarten teacher. And he would cry and he would tell her, I don't want to be like this. And he would be aggressive with other kids, but then he would cry and tell her, I can't control this. And
the kindergarten teacher remembered Mr. Chalito?
She did remember Mr. Chalito and his family because it was so dysfunctional. She said there's a report in her records that when he was 5 years old, he was wandering around the streets of Key West, smoking cigarettes, looking in garbage bins for food. I mean, this is his reputation. So it was hard for her to forget somebody like that, and she was very concerned.
Explain something to me. Did he have siblings that turned out to be fine?
He has two siblings. I mean, they graduated from high school. And
so what's the explanation organically? I mean, what happened with Mr. Chalito, if you're correct, that he had some significant organic brain damage? What was the situation? How did that happen?
What the experts, Dr. Reebsame and Dr. Sarkis and Dr. Beaver all sort of talked about the fact that there is this incident reported by the mom that when he's 5 days old, he chokes on some milk, and he's taken to first a clinic, and they say, we can't treat him. This is too serious. And so then he's taken to the hospital, and he's kept overnight, and they basically tell the mom that there's been the airway's been restricted, and they feel like there's been a problem getting air to his brain, and that they tell her, you have to watch him. And basically then she takes him for his appointments, and they just keep telling her, you have to keep an eye on him. And it's not till really he gets to school and these educators sort of see this behavior and this unusual, clearly disturbed child who gets immediately placed in the emotionally handicapped classroom that that this starts surfacing, that there probably was a problem from when he was an infant and that incident occurred. Also the malnutrition, I think, is a big part of it, because he was not being fed adequately. He was eating things at school that kids shouldn't be eating, and so that could also be the mental health experts actually testified that could be another source of the brain damage. And that really is what distinguishes him from his siblings, is the fact that it seems like he's got this mental health issue, which is, according to the experts, an extreme mental or emotional disturbance.
And it all started because he choked on some milk.
Right, he was choking, his airway was constricted, so he wasn't getting oxygen to his brain, and the theory is that that's what caused
we don't really
much
know.
of this damage.
There's some bizarre things about this mother that's testified to by us. Very bizarre things.
Yes.
Whether there was something really more there on the part of the mother, and we just don't know that.
Right.
I'm not going to go through in open court what apparently she did with him, but it doesn't sound like it was a very healthy relationship.
Right. In addition to the mental health, I think that is clearly, there were these red flags. We talk about these red flags, and there were the red flags that you should have had an expert go in and do a full workup with Mr. Chalito, or even just talk to Dr. Sarkis, who was his treating psychiatrist back at Grant. But in addition to the mental health, then we've got this whole family dysfunction, which all of the experts say contributes to these mental health problems, because for somebody who's got organic brain damage, they really need a lot of stability, a lot of support. Parents need to follow up, especially when you're a child and someone tells you have to follow up, you have to go to these appointments and do this counseling or make sure he's taking his medicine. You have to have a stable family environment, and this was anything but that. It was just clearly chaos and dysfunction and abuse and neglect from when he's just a baby until all the way through.
I want to ask you about the abuse issue. There was the testimony by Rebecca Chalito.
His sister, yeah.
Is there? It sounds to me like there might have been sexual abuse. Was that ever developed?
Right. I mean, Rebecca talked about this behavior with her mother, and her mother not only, with her sort of prostituting Rebecca out, and also the individual she brings into the house who molests Rebecca, who's the cousin. And so there's sort of no safety for these kids. And then between the mom and Mr. Chalito, there's also this behavior of him sleeping with her till he's 14 or 15 years old, having him simulate breastfeeding, having him show her his genitalia. And this is also going on. And Rebecca sort of says, this was kind of normal for us because this was my mom. But when you start asking the experts about that, they clearly call this sexual abuse. And along with that, there's the physical abuse. I mean, clearly the mom likely suffers from some sort of disorder, and she's going through these phases where she gets very depressed and she strikes out at her children.
Okay, you've spent a lot of time on deficiency. It's, although he's only 18, the crimes that he committed in not only this crime, but what he did after, and how does that change the balance where a jury would have been more likely to recommend life? How does it undermine our confidence in the outcome with these strong aggravators?
Well, we have two aggravators, essentially, because two have merged. So we have a prior violent felony.
But we have a lot of, it's not like one prior violent felony. We've got all those felonies, the armed robberies that occurred. It's within the time period. It's after the murder, right?
Right.
Those occurred. But that's not just one. I mean, it's merged, but we can't. It's pretty aggravating. What happened.
We have prior violent felony, and I think they introduced 4 of those, and then there's the merged pecuniary gain and committed in the course of the robbery. But if you start looking at what could have been presented to tell this individual's story and what the jury would have heard about, sort of the frailties of Michael Chalito and whether or not he was morally culpable and deserved the death penalty, you would have an explanation for this person who basically is functioning under the constant poor impulse, poor judgment, poor reasoning. Something happens to Mike Chalito and he reacts. He doesn't process like us. He just reacts to that. And that reaction can be violent. And when he's treated with medicine, he calms down and it's effective. But he was never given that opportunity to have the medicine and have the stability and have some residential treatment so that he could actually get to a position where he could not have these reactions. And so, if you look at the prosecutor's closing argument, he constantly tells the jury, this is the character of this defendant. This is the violence and what he's doing, and then no remorse. This is his character. But really, the explanation was the organic brain damage and the depression and the bipolar. And what's going on mentally with him is causing his behavior. I see that I'm into my rebuttal.
Down to less than 4 minutes.
Okay,
So.
if I could reserve. Thank you.
Steve White with the Attorney General's Office representing Appalachia. Mr. Eller did obtain 243 pages of records, and it's not exactly clear precisely which records he got. In fact, he testified that he had no independent recollection of exactly what records he had obtained, but there was documentation that he obtained 243 pages of records.
I think the problem really is, for me, I mean, I could get today 500 pages of records or 1,000 pages, and I'm starting a trial in a couple of days. I don't know how you got a kid who's almost 19, but he's, for many of us,
1 month shy of 19,
pretty young. Especially in terms of the fact that anyone under 18 cannot be executed. And you get them all, but you don't have time to process it. And what is being portrayed here is really somebody that was sort of only one lawyer, when many times, and now almost all the time, there's two lawyers. Not that that's required.
Well, I believe you did consult with other people, Your Honor.
You find out that this almost 19-year-old has had a lifelong history of mental problems, hospitalizations. A personal injury lawyer would, if they've got those records like 2 days before trial, how do you don't process that? So would you focus on the prejudice for us? Because to me, I see there is deficiency. I do. My colleagues may not. But I would like you to go over the prejudice.
May I talk 1 minute about deficiency?
You can talk about it as long as you want.
Going back to the log sheet, and Mr. Eller testified about his log sheet in terms of being paid, and he indicated that not every single item is on the log sheet, but things that are on the log sheet. Going back to June 26, 1995, 1.75 hours reviewing mitigation documents provided by the parents.
Okay, if you want to go back to that, when was Mr. Eller hired for this case?
I believe it was February, Your Honor.
Of 1995?
Yes, ma'am.
And when was the trial?
The trial was in July, I believe. Yes, ma'am. July 17th, the trial started.
So the first time he's looking at mitigation is a month before the trial?
Well, no, he didn't say that. In fact,
no, I'm asking you though. When did he get? Did he not get the records like within a few weeks before? If whatever he got within a couple of weeks or maybe a couple of days before the trial?
Well, he wasn't sure, but he thought he may have gotten some records from the PD from whom he inherited the case. But part of the problem is when he got his file back to review for the evidentiary hearing, it was disorganized and he wasn't sure that it was totally complete. But he did discuss on his timesheet June 20th, he worked on mitigation. As I indicated, June 26th, he worked on mitigation. And I would disagree with opposing counsel regarding the motion to appoint Dr. Miller back in April, that the motion itself, and this is on page 15 of the record, cites that he wants, Mr. Eller wants Dr. Miller appointed so defense counsel could better be able to represent the defendant. Basically, it's an open-ended type of motion. I mean, yes, the main focus is on competency, but it's not limited to competency. Of course, the two overlap in any event. Defense counsel testified at the evidentiary hearing, I was working on mitigation as I was working on the guilt phase. And accordingly, Dr. Miller's report, which is dated April 21st, 1995, discusses the defendant's general mental health, including alert and lucid, and, of course, diagnoses him as antisocial personality disorder, which greatly troubled Mr. Eller in terms of his strategy in not pursuing ultimately not pursuing Dr. Miller. Of course, he rehires Dr. Miller later and provides him that summary sheet from Grant Hospital. And the summary sheet basically included the main features that defense counsel is talking about.
But he doesn't have, you see, if I look at our direct appeal opinion, and it says that one of the judge is evaluating that the defendant would frequently argue with his mother and have his temper tantrums and threaten when he could not get his way. And he goes on, he's for short periods of time been in several treatment and diagnostic facilities. This may be marginal mitigating expert circumstance. I assign it slight weight. And then we say, we, the court, during the penalty phase proceedings, Chalito presented no medical or other expert testimony to support his claims of organic brain damage or other impairment. Further, the evidence submitted to support his mental condition was conflicting. I mean, they were, so we seem to be, we say on this record, we cannot conclude the trial judge abuses discretion in finding this mitigating evidence to be slight weight. Yet we've got this picture of somebody that from a young age is not normal. I mean, this is, it's not like he gets into adulthood, has this normal life, and then all of a sudden he starts to commit crimes. This is a child that is, if I understand correctly, from kindergarten, is acting in a most bizarre and disconcerting way that in this, if any of us had observed that, we would have said, this family needs to be referred to DCF to see what's going on.
Well, Your Honor, with all respect, this goes to both deficiency and prejudice in terms of what defense counsel was able to gather and present at the penalty phase of the trial. Through the family, defense counsel not only introduced a lot of these same facts, but also cherry-picked the records and selected out the ones that wouldn't harm the defendant, but which would help him, including presenting before the jury some key facts that Chalito was in special education, that he stuttered badly, the father was physically abusive, and there were specific descriptions as to exactly what the father did. Again, these are all facts presented in the penalty phase. Chalito helped his mother. The father was an alcoholic. He hung around with the wrong people. Again, details about the father putting Chalito through the wall and hitting Chalito and damaging his tongue. Learning disability, specific reference to the Grant Central Hospital records. Again, I don't think the record is as clear as opposing counsel makes it out to be in terms of...
The defendant was raised, this is what the trial judge found, in a stable, lower middle-class home. What I just heard, was this a stable, lower middle-class home that he was raised in?
Well, it depends on... There's evidence of stability, the loving mother. Now, the mother that was presented at post-conviction is not the same mother that defense counsel interviewed and put on the stand in the penalty phase. But the record is replete, the log sheet is replete with defense counsel interviewing the mother and the father in preparation for the mitigation phase. And so defense counsel then has the mother, who he presents to the jury as a very sympathetic figure with this abusive father, and she's trying to do the best she can with the situation. In terms of an example, she sought help when she couldn't pay the bills because the husband was out at sea and she didn't have money. And this goes to the fact that she was the glue holding the family together in terms of the image being presented to the jury in the penalty phase.
Do you think that in American society that if you present to 12 people off the street that there is a child that has organic brain damage, not personality issues, not emotional issues, organic brain damage, meaning structural damage to the brain, give the reason for that, turning blue, choking, turning purple, some of those, that's eating pencils and can only survive as a very young child in a social context, i.e. school, with special comfort from the teacher, that would have some bearing on 12 citizens of Florida?
Well, two things, Your Honor. In terms of the situation defense counsel was in, he had an indication of organicity, and he presented that to Dr. Miller. But Dr. Miller said, basically, I recommend you don't use me in the penalty phase.
Let me ask respectfully, why would you go to someone else when you've got the doctor available to testify about the organic brain damage? Or those people testified, did they not, who had been involved in his care?
Well, ultimately, aside from the strategic decision not to endanger the facts to the jury in terms of presenting details of antisocial personality disorder, aside from that, what we learned regarding the prejudice prong is that they present Dr. Wu at the evidentiary hearing.
I'm not talking about Dr. Wu. That's a PET scan person, right, from California?
Regarding organicity, though, Your Honor. But Dr. Holder testifies...
But the grant records were not based on PET scans, were they?
I don't think so, no.
I mean, that's long before I even knew what a PET scan was.
But, I mean, frequently that's what we hear from the defense in terms of...
this case, though. I understand frequently here, but I'm really seeing a sick young man demonstrated in the records, and then I'm not saying that they would or would not have followed, but to not present that to a jury is beyond me.
Well, they did present it, but through the records of the family.
Let me add it again, through an expert that can explain to jurors, lay people, what this means.
Which would have opened up the whole can of worms in terms of his prior criminal history regarding antisocial.
We hear this all
in terms
the
of the tactics.
Well, this is a can of worms. I mean, no matter how you turn it, is it not? I mean, there's no evidence that this is all phony, is it? Is there any evidence that this is phony? The medical, mental health issues?
Well, in terms of the PET scan and what it revealed, Dr. Holder testified that it was absolutely normal.
PET scans, and we can have. I'm talking about the other medical records. Is there really a dispute with regard to the underlying medicine?
Well,
is there? I just please help me.
And in terms of actually whether there was any organicity somewhere in there, I mean, I can't categorically say that there's any evidence that says absolutely not. I mean, the evidence was disputed, and of course, the position defense counsel was in, he had on the one hand this additional way of proving the same thing, the organicity. He put on evidence of the organicity. He just didn't use an expert. But using the expert as defense counsel reasoned, it would have opened the door to this guy's entire criminal history and cross-examination of the expert. It would have opened the door.
The opinion of the trial judge says the defendant's total criminal records as a juvenile and an adult shows he had been arrested 22 times, been charged with 30 separate crimes, and has now been convicted of 8 felonies as an adult. Did that not... That's what the trial judge found. So did the jury not have...
No, ma'am. The jury had the prior violent felonies.
So where did the judge find that?
The judge used that information in terms of giving slight weight to the age factor. He said, this is a man, this is a...
So we had that evidence.
The judge did, yes, ma'am. The jury did not hear this other evidence.
Then we're talking about whether judge or jury. The judge then needs to have an explanation for what could go wrong with a child that starting at 13 is committing crimes. It is maybe it doesn't end up saving him from the death penalty. Maybe it doesn't. But I think what Justice Lewis was asking you, and I've been also trying to ask, is it's a different picture than when you take someone that has the parents, somebody testifies, he was a good kid, we had a very nice childhood, but, he was in special education classes. It's like, no, this is a very different scenario. This is some heavy stuff about what happened to this child.
And additional heavy stuff that would have been introduced if defense counsel had called Dr. Miller to testify.
I mean, you already know that this man has killed somebody for no reason, and he has committed armed robberies. I mean, to hear that he did that starting at age 13, either this is one of these bad seeds and we better give this kid the death penalty, or something that was beyond his control went terribly, terribly wrong in his young life. It's not an excuse, as we say. Mitigation isn't an excuse for the crime. The question is whether the jury, the judge, and this court needed to have that information in order to properly evaluate whether this was one of the most aggravating crimes and the least mitigating crimes. That's all we're talking about here.
Yes, Your Honor. Again, though, the trier of fact did have those mitigating facts before. They just didn't have an expert, which they, by the way, they put on, for example, Dr. Reevesane, who testified about the damaging effects of antisocial personality disorder, the prejudicial effects of it in cross-examination. Basically, the criminal mind. This guy is a criminal. And if we want to flesh out more details in terms of what wasn't presented, but could have been presented in addition to, now we're talking about the Spencer hearing, And defense counsel gave an explanation that he thought Judge Olaf would react very negatively to antisocial personality disorder, and that was his rationale for not calling Dr. Miller for the Spencer hearing. But now, keep in mind now, for the jury didn't hear any of this other prior criminal history in terms of the details of all of his arrests, juvenile arrests. Things that the judge and the jury didn't hear about were, I think there was an incident where the defendant threatened to come back and kill a staffer at one of the institutions he was at. The judge or the jury didn't hear about that. The judge or the jury didn't hear about the defendant grabbing an officer and threatening him with a volleyball pole. The judge or the jury didn't hear about threatening to gun somebody down. I have friends outside that are going to shoot you.
That all sounds really good, but where was this information? And
this additional information were in the records that they obtained for post-conviction, or that defense counsel had but didn't use at the trial.
Okay, but it still doesn't sort of connect of why you wouldn't have had an expert just because you have this other information in some records doesn't necessarily follow that it would have come out if, in fact, you if there had been an expert to testify about possible brain damage.
Well, if I may get to the prejudice prong, I'm sorry, I didn't understand your question.
The question is, even though you have that information in some records, it doesn't necessarily follow that it would have come out if an expert had been presented at trial. That's what we're really talking about. Why wasn't there an expert to bring up this mental mitigation?
The test, though, Your Honor, is the reasonableness of counsel in assessing the situation he was in 1995. He has hundreds of pages of records. He may have had other records, we're not sure, from the PD or otherwise. And those records show incident after incident after incident of bad acts, threats, violent acts that bootstrap into antisocial personality disorder. In the situation defense counsel was in, he reasonably concluded that the prosecution would have used those incidents against the defendant and cross-examining the defense expert. And in fact, that's exactly what the prosecutor did, for example, in cross-examining Dr. Reebsang. He went into details of antisocial personality disorder in terms of how prejudicial it is, and this gets to the prejudice prong. Antisocial personality disorder would have been in terms of allowing the state to introduce all these details in front of the jury of all these prior bad acts.
What do you think a jury does with a kindergarten teacher that remembers a child that is so different from everybody else that he is eating pencils and glue? Does that, going back to what, we can go through all this sounds like every other case, and then we lose that sometimes there's a case that's different. State wins most of these cases because we don't look back. We're just looking at a case where it appears that a lawyer kind of went through some motions, but not all the motions, that we would expect before we're going to decide that someone gets finally put to death. And so going back to this, you're sort of ignoring some of the compelling testimony that was actually presented, and that there are reasons in medical records for why this man acted the way he did starting from a young age. And I'm concerned that there wasn't a strategic decision. You say there was, but that's how we started. I don't see that this was something that was thoughtfully considered.
Well, I'll go back to the bullets in my brief, Your Honor, in terms of what defense counsel did present. I mean, I highlighted some of those aspects in terms of the facts of the defendant's background. And yes, the defense counsel did not produce an expert to put some psychological, psychiatric labels and ideology on that background. But again, which gets back to the whole antisocial aspect of it in terms of his strategic decision. But on pages 42 through 46 of the state's brief, I bulleted the facts that defense counsel was able to elicit given the information that he had. In 10 seconds regarding prejudice, prior violent felony times 4. Aimed a gun at a police officer. The gun he used, the murder weapon, aimed at a police officer, and of course he was shot as a result of it. 2 robberies right around the same time. On felony probation for aggravated assault. The aggravated assault on the police officer. The cumulative nature of a lot of this evidence, I respectfully disagree in terms of the effect an expert would have had. The PET scan, Dr. Holder, preeminent expert in terms of PET scans, the state put on the post-conviction and said that the defendant's PET scan is absolutely normal, quote unquote. For all these reasons and the ones in the trial court's order and the state's brief, the state respectfully requests you affirm. Thank you.
In the grant records, in the records that were introduced at trial, I think it's a total of 9 pages. On the first page, Mr. Chalito is brought in because of aggressive behavior, homicidal and suicidal threats. This is what the jury had to look at. He was diagnosed with a conduct disorder. You
said that the jury had that to
This was what Mr. Eller gave to the jury. He talks back to teachers. He has problems with the law. He was charged with trespassing in a mini storage, and then those charges were dropped. Dating back to 13, he was accused of trespassing and stealing motorcycles. He was arrested for arson in August and burglary. He's said to have started the fire at the mini storage. Truancy, fights have led to DDC, which I guess is the juvenile facility in Jacksonville. In Dr. Mullen's records, he lied about, his friend lied about him being the one who set the fires. That's Mr. Chalito's story. He stole guinea pigs from the pet store. I mean, these few pages that got introduced are just littered with criminal history and references to homicidal thoughts. I mean, the idea that you'd give that to a jury without explanation when an effective attorney could literally have a jury in tears about this kid's background and mental health problems. There was no excuse for it. In terms of the prior violent felonies, I did want to point out that Mr. Chalito had a drug and alcohol problem. He was using drugs and alcohol at the time of the murder and at the time where he was arrested during the raid and the robberies that occurred previously. The blood alcohol content was, when he was taken to the hospital, was 2 times the legal limit. So there were explanations in addition to the brain damage as to why the weight of those aggravators should not be as high as the state would like to have them. In mitigation, obviously there would be a wealth of mental health evidence. Also, the age statutory mitigator would have been something that could have really been flushed out more. Every expert who ever saw Mr. Chalito.
Let me just ask you this question. If we accept, and all these experts seem to say, that he has organic brain syndrome, what exactly does that translate into about his behavior?
It means that when in his functioning, he can't think about when he's confronted with something. He doesn't process the information, think about it, consider the consequences, and then react. He reacts. He's impulsive. They also say he...
So he's impulsive, and this is, as I remember this case, they wanted to rob him, or he wanted to rob the victim, and when the victim had nothing on him, his impulse is just to shoot him.
Well, that was what the statements he had allegedly made to other people when he returned to the house were that because the victim didn't have any money, he shot him. And so, again, what the experts sort of say is they're going to assume he's guilty. They're going to assume he did this. And then when you look at that and you look at that behavior, it's predictable. It's what would happen because he's standing there with a gun and he's mad, and so he shoots him. And so it's sort of this impulsivity, this failure to think about things and to understand the consequences of his behavior that he just reacts. And this is his life. This is what, in the sentencing order, there's all sorts of things about him not having having jobs, and this is Michael Chalito's life. He can't do those things without stability and without medication. And I would ask the court to reverse the circuit court and grant relief.
We thank you both for your arguments. The court will now stand in recess for 10 minutes.
All rise.
Is it? But you were also on cruise, weren't you?
Supreme Court of Florida is now in session. Please be seated.
We now come to the third case on our docket, McKenzie Check Advance of Florida versus Betts.
May it please the court. My name is Himeme Bianke, and I'm here for McKenzie Check Cashing Advance of Florida, Mr. McKenzie and Brenda Lawson, who are the defendants below. The Fourth DCA has certified a question of great importance to this court, and that is whether an arbitration clause, which does not limit any of the statutory remedies that are provided for under FDUPTA, but which contains a class action waiver, can be enforced, or does it violate the public policy of the state when the trial court is persuaded that the waiver prevents a consumer from obtaining competent counsel?
In terms of that question, I have two questions on that. Does the class action waiver prevent, in this case, the consumer from joining a government-initiated enforcement action?
There's questions about that in the opinion below, but when you look at the language of the decision, it bars them acting in a pars parenti status, but I don't believe on its core would prevent them from joining or seeking relief.
So representing McKenzie, your position is no, it would not prevent them from, that wasn't the intent of the
clause. No. For example, it would prevent them from serving as a representative. Let's say the Attorney General would bring an enforcement action of some kind, and the Attorney General collects X of Y dollars. Presumably, that money would be refunded to people who have been aggrieved, and the clause itself.
After this case came out, Concepcion came out.
That's correct, Your Honor.
And it would seem, and maybe this is sort of a friendly question for you, that Concepcion really takes the certified question and really obviates it, because it seems that this would, especially looking at Cruz versus Singular from the 11th Circuit, that right or wrong, we're bound to follow the U.S. Supreme Court. And I guess I'll ask your...
I would agree with that, Your Honor.
Yeah, I assume you did. It seems to me that this arbitration clause doesn't, other than preventing them from being a member of a class, as you said, all the statutory remedies are preserved, and you've got in this situation a plaintiff who's got damages that exceed $24,000.
That's correct.
But also, the other odd thing is there are class actions that are pending in circuit court against McKenzie, but they were part of a class that was certified before the agreement was changed with the check cashing company, correct?
There are, and I believe there are even some that don't even contain an arbitration clause.
We had the earlier reiterations of the case, but that's not part of this record. But it just seemed to me this one was joined, but then she's got the arbitration, but there are earlier plaintiffs that really can sue and vindicate rights, but nobody really brought that out. I guess what I was thinking is she really can ride on the coattails of this other class action anyway.
Well, I'm not sure she could join the class action. I think she
couldn't join it, but in terms of this being a difficult case, it's getting the issues are being litigated through the class action, aren't they?
Well, some of the issues are being litigated. I would say this. There is a great degree, and it's true in most of these cases, irrespective of this one. When you look at them, there's a great degree of variety associated about what the underlying agreements are. And obviously, even post-Concepcion, trial courts have to look at what the clauses are or not, and they're applicable, what they contain or don't contain, and make the decision as to who would fit in those classes and who wouldn't.
Well, when you say post-Concepcion, I'm reading Concepcion to really not care too much about how bad the remedies are, that it's just preempted because unconscionability, public policy, more end up impacting arbitration more than other kinds of contracts, and therefore the Federal Arbitration Act trumps anything the state may think about either the public policy or unconscionability.
I would say I wouldn't quite go as far as you go, Your Honor. I would say...
I don't want to go... Yeah, so you stop before what?
Okay, I would say if you look at Concepcion, specifically, the issues are articulated by the Fourth District. Those issues about whether, in fact, a class action waiver in itself is going to be exculpatory, and if it's exculpatory, does it mean it's unenforceable under the laws of the state? I think that question's been answered. And it's answered by Concepcion. It's been answered in Cruz. It's just been answered in the Ninth Circuit and CONF.
So you would say if there's a case, for example, Schatz, which is out of this court, they eliminated punitive damages, which was a statutory remedy. Those would be different types of cases?
I think those would be different questions and more difficult ones that the court would have to look at those clauses in more detail. I don't think it's going to be automatic, per se. I would agree with that. I think the court would have to look at those clauses and see what's there or not there. But this question that's been articulated by the Fourth DCA controls the decision and requires that the court answer the certified question in the negative and remand to enforce the arbitration clause here. This clause, the arguments are being put forward that the class action waiver is exculpatory, that somehow one is going to introduce an evidentiary record to support that proposition, and the trial court is going to make a determination about whether or not to enforce an arbitration clause or a waiver in an arbitration clause because of it has all been answered. And whether it's a small value claim, which arguably this doesn't even fit in that category, but assuming it were, all those questions have been answered. But the answer ends up being answered because of Concepcion, not because of whether the Fourth District is right or wrong on its public policy analysis. Well, I would say obviously the Fourth District didn't have the benefit of Concepcion when it argued. We had that argument below, and certainly before it issued the opinion before Concepcion came out. But what I'm saying is, even if the Fourth District is correct that you can make a determination of whether something violates the public policy based on the testimony of three lawyers that are consumer lawyers, even if they're correct on that, we don't need to get there because the way they've analyzed it, Concepcion still says the class action waiver is appropriate. Yes, I would agree that the public policy of Florida cannot be, the class action waivers cannot be enforced. Would it be different if the legislature explicitly said as to FDUPTA that there shall be no class action waivers, that would be against FDUPTA? Or does the U.S. Supreme Court, they seem to care if there's a competing federal statute, like in Mitsubishi and all those others, but they don't, the question is, would they care if the state clearly said our policy is we're against class action waivers? I think, especially, and the short answer is no. It would make no difference. The legislature tomorrow would come and say, into FDUPTA, we like class actions. You cannot waive this right in a FDUPTA claim. The Supreme Court just issued a decision where it reversed the Supreme Court of West Virginia in a decision called Marmette, which was a 9-0 decision, where they had limited pre-dispute arbitration provisions. And certainly at this point, it's not an issue of whether arbitration is good or bad, but it's an issue of the supremacy clause. So I would say no. I would say the answer to that would be no. But you do agree that you would look to see whether any, again, in Cruz, the 11th Circuit went to some length about talking about all the good aspects of the AT&T agreement, which were, some of them were pretty impressive, like you'd get you get at least $7,500 and you'd get double your damages if you did better than AT&T's last offer. So you don't think, that's what the 11th Circuit said, you don't think it at all would matter as to whether those kinds of things were preserved through arbitration so that it was at least a fair forum for the consumer? Well, I would say this, because the question, I think, introduces two ideas. What is the concept of fair and not fair? I think what you have to look at is if the arbitration clause takes out remedies that are statutorily provided for, triple damages, punitive damages, things like that, I think that the courts certainly, and one would possibly think that the unconscionability analysis would still come into play in some of those issues. But again, that's not the question presented here. I don't think that, let's say the clause had special incentives, let's call them contractual incentives, not statutory incentives. That's not part of the holding of Concepcion. When you read Concepcion in fairness, from top to bottom, while they do mention the AT&T factors that particular clause had, it was not part of the decision or the holding of the case that you needed these special incentives to sort of justify the arbitration clause or hold it up.
Well, what do you say about their argument that this all depends on what Justice Thomas thinks?
With all due respect, the Supreme Court has already made that analysis in Allied Termite. We cited it in the briefs. It applies. Obviously, Justice Thomas has a certain perspective when it comes to the applicability of the FAA for state law questions. But again, he joined the decision joined the decision in Concepcion. So certainly, the holding of the case still stands.
Well, how would you, okay. It seemed, though, that Justice Scalia went to some length to talk about how, under the Discover Bank rule, that really virtually anything would be unconscionable because it meant small damages, and then you allege fraud or something. And he was saying, well,
contracts of adhesion, small.
And then so it was virtually the entire universe.
Well, I thought the key part of Justice Scalia's point there was a malleable standard, that there was no standard because it's malleable. And I would say, although it's not necessary to reach the decision here, essentially what the Fourth DCA has provided this court is an equally malleable standard that would not support.
And that's what Cruz really criticizes.
Exactly.
I see that as...
In part, that is correct. That is correct. So certainly, we would say that the question that the Fourth DCA presented to the court based on Concepcion, based on the Ninth Circuit just recently came out with a similar decision in CONF, specifically even arguing that vindication of rights only applies to federal claims, not state claims. You have the decision...
So much for states' rights, huh?
Well, it was an interesting argument at Concepcion. Counsel was there present, too, as I was. It was an interesting argument that the court had, but certainly the FAA would trump public policy arguments to the extent that it would prevent the enforceability of an arbitration clause as written with the traditional, and there's like a footnote in Justice Scalia's opinion, I think footnote 6, preserving the traditional procedural and conscionability issues that have been part of the law forever.
But just to make, as far as this claim is concerned, though, there is nothing in the agreement that we could look at and say this is an unfair arbitration clause other than the idea that you can't litigate it as a class action.
That is correct. In fact, the trial court below found that there was no procedural unconscionability, found that the claimant, in fact, self-proclaimed genius IQ, understood the agreement in its totality. She needed the money for very personal reasons that were not really even requirements of life, let's say.
As an aside, could a consumer come in and scratch out the arbitration clause and still possibly get any money from these kinds of places? If I come in and I say, look, I want to do business with you, but I don't want to be bound by this arbitration clause.
There's nothing in the record that would support the proposition that you could scratch it out. There was a one-day, you could rethink it after one day and return and cancel the transaction. This particular claimant had that.
That to me seems to say procedural. I mean, there's nothing a consumer really could do about these kinds of contracts.
Well, a procedural unconscionability, for us to really have made a thorough analysis, and like I said, there's nothing in the record to support that there was. In fact, it was the other way. You would have to see what other availabilities of credit she had or didn't have available to her to really make those kinds of evaluations. And like I said, there was no duress, no compulsion on her part to borrow this money.
But we're not here on the issue of unconscionability.
No, not at all. Not at all. That was not even part of it. Unless there are any further questions, I'd just rather reserve my time for rebuttal.
I still hate these things.
If it please the Court, my name is Paul Bland. I represent the appellee in the case. Your Honor, Justice Parente, you said, is there a different answer for the effective vindication of rights doctrine from the Supreme Court that says arbitration clauses are only enforceable if you are allowed to effectively vindicate your rights if it's a state statute versus a federal statute? Okay, the answer you got, I'm afraid, was wrong. Totally disagree with it. And the Ninth Circuit in the Conniff case and the Kilgore case, completely wrong. If I could turn the Court's attention to a U.S. Supreme Court decision from 2008 called Preston versus Farrar, the Supreme Court clearly said that the effective vindication of rights doctrine in an arbitration clause applies to state statutes. Now, it's a weird state statute. It's a California case. They have a talent agent statute that the legislature felt that talent agents were mistreating young singers and actors and so forth. And they said that you have to go to an administrative agency. And the Supreme Court said, well, this is preempted by the Federal Arbitration Act because you have a right to go to arbitration or there's an arbitration agreement, and the state can't say no arbitration clause, go to the administrative agency. But the Supreme Court said, we know that we only reach this conclusion that the state law is preempted because, and this is at 552 U.S. at page 352, we only reach the decision because the plaintiff would relinquish no substantive rights under the Talent Agent Act or other California law may accord them. And then they cite the Mitsubishi Motors case, which is the U.S. Supreme Court case that said that arbitration clauses are only enforceable where parties can effectively vindicate their rights. So we got two lines of Supreme Court.
Mitsubishi, was that a federal statute?
That was a federal statute, but Preston was not.
Well, because, you know, we will not have time here. We've all read all these U.S. Supreme Court cases, and you know, we can't divine what goes on as far as in other situations. But this is FDUCTA.
Right.
And unlike Schatz out of this court, the plaintiff, in order to file her claim and through arbitration, did not give up any of her rights under FDUCTA. Is that correct?
No, Your Honor, and here's the reason.
There are no statutory rights that she gave up. They didn't require her to waive attorney's fees, did they?
My answer is still no, and I can just quickly explain. The Supreme Court standard here is, are you able to effectively vindicate your rights, not formally. So if there's a procedure that's set up that bars somebody from being able effectively in the real world to vindicate their rights, then that renders the clause unenforceable. So, for example, in the Randolph versus Greentree case in the U.S. Supreme Court, the question was, are the costs of arbitration too expensive? Now, that's not saying, no one said, the bank didn't say, Greentree didn't say, you lose your rights under the Truth in Lending Act. So there's no explicit thing. So it wasn't like Schatz. It wasn't like Schatz where there's a clause in the contract that says you lose your remedies. But there was a challenge to the cost of arbitration. And what the Supreme Court said was the plaintiffs in this case didn't prove their case. They didn't have any evidence. But Chief Justice Rehnquist, then alive, wrote a majority opinion. He said, if the plaintiffs had proven with admissible evidence that the costs would be prohibitive, then the arbitration clause would not be enforceable. But here they didn't prove it. So the point is that where there's a procedure that does the same thing, that adds up to the same thing as what you had in Schatz, which was a clause that explicitly took away a remedy, a procedure that ends up gutting the rights effectively is enough to render the clause unenforceable under federal law. And the Randolph case shows how to try and reconcile these two lines. Because you have two lines of Supreme Court authority. So you got the Concepcion case that says, generally speaking, an arbitration clause that bans class actions is going to be enforceable. But they never took away the pre-existing half-dozen cases where the Supreme Court had said that if an arbitration clause would prevent you from effectively, not formally, effectively vindicating your substantive rights, then it would be struck out.
You can't really be looking at us with a straight face and saying that this U.S. Supreme Court is going to accept an argument that 3 consumer advocate attorneys who say they wouldn't take this case back in 6 years ago, and that's the basis for finding that this claim is void against public policy, is going to say, oh, well, when there's that kind of testimony, we didn't realize you might have that kind of testimony, that we will we will void the class action waiver. I mean, you know, we're here with the hand we're dealt, which is, in this case, the U.S. Supreme Court, and every single decision since then. And I just find it, I guess, especially in this case, unlike Pendergast, where I think there's some real issues on the unconscionability. Are you on that case?
Yeah.
Okay. Is that here you've got a $24,000 claim. You've got some attorneys that say, I wouldn't take it. Yes, the law was difficult maybe back in 2005 or 2006, but the law has been straightened out. And I just find it to be a little strange that we're going to have law that says the public policy of whether something is upheld or not is going to be based on whether a particular judge at a particular time takes some particular attorneys and gives those attorneys credibility versus the attorneys on the other side, and that's how we're going to decide whether this contract is void against public policy. I think that would, to me, that is a less honest way of approaching these cases because it really does mean that it's a battle of attorney experts as to whether something's void against public policy.
May I respond?
Of course.
Okay, first of all, not every case has gone the way that the Cruz case has. We cited in our supplemental authorities just a few months ago the Second Circuit in the In re American Express case, looking at expert witnesses, found that a ban on class actions and just a ban on class actions would gut rights under the antitrust laws and would therefore, and because there was an evidentiary record that it fell within the effective vindication of rights and was an exception to the Concepcion rule. So that's the best case on this point.
And that, again, is a federal...
And that's a federal statute.
So I'm just having
the Preston case says that same doctrine applies to state statutes. Preston is an 8-1 U.S. Supreme Court case. 8 justices of the Supreme Court said effective vindication applies to state statutes.
And
so if
year,
American Express is right, we can
case?
win this suit. The case was Preston versus Farrar from 2008. So, second, you've denigrated our factual record in the trial court. Let me respond to that a little bit, if I may. Okay, first of all, there were no arbitrations at all. So it's not just 3 lawyers saying, well, in theory, I personally wouldn't take a case. There has never been an arbitration against these defendants. So that's a key fact. Second, we didn't just have lawyers saying, well, I wouldn't take a case. One of the experts who we had was a legal aid lawyer who gets a great number of people who have problems with payday lenders who approach her because she's been working with the military on these issues where she helps out people fighting sort of debt collection defenses. And she said she had attempted to find on a number of occasions a lawyer who would represent an individual against a payday lender making the kinds of challenges that we are making here and that no one would do it. So she's not just saying, well, I personally wouldn't do this case. She said, as a legal aid lawyer, I've tried to find private lawyers to take this case, and they won't do it. We also had evidence that legal aid lawyers aren't willing to take these cases because they focus most of their resources now on the foreclosure crisis. Moreover, in addition to the 3 experts sort of going through what happened to them, they came in with some evidence. Well, yes, there are some small cases, small dollar value cases that could be pursued in small claims court, and here's a bunch of examples. None of those examples were cases involving usury claims or payday lending. Then, moreover, when we challenged, we had one of the executives of the company on the stand and questioned him about how would you defend these cases, and he said, well, we would only settle one of these cases if there was a confidentiality provision that would keep anybody from knowing about it. So we have a lot more of a factual record than just a few things. With respect to the $24,000, if we win absolutely every single conceivable claim in this case, which, first of all, when the Supreme Court decided this case earlier with respect to the question of whether or not these loans were loans or whether they were just fees, because they were saying, oh, well, usury doesn't apply to us because it's not a loan, it's just a fee. So it came up to this court. This court in footnote 1 said, well, we're not going to answer a major substantive question. We're going to leave open. We're going to leave to be decided down the road as to whether or not the fact that there's this a letter from someone in the bureaucracy that said what the payday lenders was doing is okay is a complete defense. So before anyone can actually win this case, they have to come back here and win on the merits, even if it's an individual case. So when the 3 lawyers talked about how no lawyer would be willing to take this case, several of them said, we're willing to handle small dollar value cases that are straightforward types of cases, like a case like a debt collection case or type of case that we see all the time. But this case, in which basically the theory of the case was that payday lenders at that time were operating illegally, where the entire theory of the case is something that goes right to the core of the industry, that the industry is fighting back really intensely about, this is something that's really complicated, would be really a difficult case to bring. So they weren't just saying, I personally wouldn't take this case. They're saying, I don't know anybody who would take this case. And the truth is, no one has taken the case. And we have the fact that several people had gone to it. So this court...
But my concern really about the public policy argument and how that would work for the U.S. Supreme Court is that the way, that as opposed to this being a broad rule that it's against public policy of fiducia, that the Fourth District opinion is hinged on whether this trial judge found your experts more credible, so that at that time and place. So next time we could have a judge in Orlando hear different expert lawyers and believe the lawyers for McKenzie and find a different result. And I'm just not, I think that is that kind of thread for public policy that really isn't linked to the case itself, but to the type of case, fiducia, and then is a concern because it really means it's on a case-by-case basis where the judge is making a credibility decision about the experts that are presented.
Well, the policy is always the same. But then whether or not the policy is meant is a question of evidence. The Supreme Court's agreed to that. So the policy is that you can't have a contract term that prevents people from effectively vindicating their substantive rights. That's the policy. Now, is the policy met? What the Supreme Court has said is that that's a factual issue. So in the Randolph case, the plaintiffs came in and said, well, this might be a really expensive arbitration clause. We aren't sure. The 11th Circuit said, now, the arbitration clause itself didn't say anything about who would pay anything. So the plaintiff's argument in the Randolph case was, we don't know how much it'll be. It's a blank check, so we're afraid of going forward. And the 11th Circuit said, okay, you don't have to arbitrate because you don't know how much it'll cost. It goes up to the Supreme Court, and the Supreme Court said, look, if you are the plaintiffs and you are challenging an arbitration clause, you have a burden of proof to come in with admissible evidence to show that, in fact, in this case, that it would be prohibitively expensive. There's a second Supreme Court case that turns on the evidence, if I urge you to look at this one, too. It's the Pietz, P-Y-E-T-T, versus Penn Plaza case. We cite this in our brief. And what happened in this case was a case about whether or not a union could sign an arbitration clause that said that civil rights claims for union members would be decided by an arbitrator rather than a court. And there had been an old U.S. Supreme Court case from the early 70s that had said, no, that a union couldn't do that, and in Pietz they overturned it. But one of the things that the plaintiffs did when they came up in front of the Supreme Court was they stood up and they said to the Supreme Court, look, the union has already decided to throw these particular plaintiffs under the bus, and they're not going to be able to effectively vindicate their rights. Now, what Justice Thomas could have done in his opinion is say, look, we're going to say that these claims are always arbitrable no matter what. But he didn't. What he said was, we agree that if you had proven that these people could not effectively vindicate their rights, we would not enforce the clause. But that is a very fact-specific matter. And there is no evidentiary record before this court, and we are not going to let you stand up for the first time in the U.S. Supreme Court and start arguing about the facts. You should have proven that below. So the idea that we're saying, yes, it's appropriate for a trial court to look at and analyze a factual record is exactly right. That's what the U.S. Supreme Court has said in several cases.
Can I ask you, maybe, so the 11th Circuit is wrong in Cruz when they say the first argument presents more difficult. It is true the plaintiffs here presented a factual record not present in Concepcion. The affidavits of 3 Florida consumer law attorneys who attested they would not represent consumers on an individual basis in pursuing their claims against ATTM, and they go on that. So are they wrong in their analysis?
Yeah, I'm afraid they are, because the Second Circuit in the In Re American Express is right. The Second Circuit said that where there is an evidentiary record that shows that in a particular case the ban on class actions would prevent people from effectively vindicating their rights and undermine the statute, that's enough. And moreover, Cruz is also wrong on a second level, because what they do is, in Cruz, is they only focus on the named representative and no one else. So if you have 100,000 people who've been cheated and 10 of them can get their money back, the 11th Circuit in Cruz is saying, oh, that's okay, because as long as an infinitesimal number of consumers were allowed to get their money back, that's okay. What they are missing is, if you go back and look at the very first case where the Supreme Court first enunciated and articulated the effective vindication of rights doctrines, it's the Mitsubishi Motors case that we cite like crazy and cited in all these other cases afterwards. It was an antitrust case, and the plaintiff said we should never be able to force an antitrust claim into arbitration because arbitration is supposed to be about things like contracts, not things like statutes. And what the Supreme Court said, and it was Justice White writing at the time, and it's been cited again and again, the case was cited in Concepcion, so Mitsubishi Motors is still out there, still alive, does not have a stake put in his heart. What the Supreme Court said was, in Mitsubishi Motors, that the antitrust laws have two purposes, compensation and deterrence. And we are going to say that you can enforce an arbitration clause in this case because the arbitration clause in this case would allow you to effectively vindicate your rights. It's not saying we're going to have an America and where there's no antitrust laws. What they're saying is you're going to have an America where instead of litigating your antitrust case in court, you're going to litigate it in another form which is just as good as arbitration. So nothing substantive is lost. It's all procedural. And they said that that's crucial, because we have to make sure that both the compensatory and the deterrent aspects of the antitrust laws are preserved. So when the Supreme Court says in Mitsubishi Motors that the reason for the effective vindication of rights doctrine is so that the statute will still have a deterrent effect, the Supreme Court's telling you something important. And when the 11th Circuit squirrels away from what the Second Circuit is saying in In Re American Express is very important, because what they're basically saying is, according to them, Concepcion reads the effective vindication of rights doctrine to be something that doesn't really matter anymore. What it means is that if it's technically somehow possible for the named class plaintiff to get their money back, it doesn't matter if the statute is grossly gutted in its core.
Well, so that you really, the argument generally would be we need to look at what the legislature intended with FDUPTA and providing for attorney's fees for prevailing parties, making our own decision that on an individual basis will not be enough to vindicate the rights that the Florida legislature gave to the consumers. And I have some difficulty, if the Florida statute said that we intend for there to be class actions, we would have an express legislative direction. But it seems to me with FDUPTA that the legislature thought they were giving enough to allow for the effective vindication of rights. And I think you agree that there weren't any rights in FDUPTA that were taken away through this arbitration agreement.
Well, they were not formally taken away, but they were effectively taken away, which is the test. But with respect to what the Florida legislature...
But there are a lot, the problem is there are a lot of wrongs in this world that you can't find an attorney for. Unfortunately, we've got a lot of low-income people that cannot afford an attorney. And so this idea...
All of our clients are low-income.
Excuse me?
All of our clients are low-income.
Right, and all of the legal aid clients are, and we have a tremendous problem with getting attorneys for, especially lower-income people. But I'm not sure that really answers the question as to whether if you can go into a arbitration forum, and what the experts are saying, that it would take $100,000 to actually bring a successful FDUPTA claim. That's really that's an unfortunate fact that maybe the remedy is in the legislature to put some more effective enforcement remedies into the statute.
If this arbitration clause had said you have to go to Alaska to bring your FDUPTA claims, there's no doubt that that would be unenforceable. If the arbitration clause had said that the filing fees for the arbitrator are $1 million, there's no doubt that would be unenforceable. The question in this case is, did we prove, and was a trial court's finding, that it would be virtually impossible for the named class plaintiff, for anyone to be able to bring their claim. And those trial courts finding that there was essentially no reasonable avenue for these people other than a class action, or those entitled to a deferential review as were those supported by substantial evidence. If those findings are correct, then the ban on class actions in this case amounts to the same thing as a $1 million filing fee or saying you have to go to Alaska in this case.
I know, but that's what really Discover Bank rule was all about.
But the thing, Your Honor, I argue the Discover Bank case, if there's any error in my life I wish I could take back, the first question I got from the Chief Justice of the California Supreme Court in 2005 was, gee, shouldn't we remand you to build a factual record? And I'd been hired to do this appeal, and I was trying to win the case on the day, and I said, no, we don't need any facts, because just a matter of common sense, you can say that a class action ban here is going to be costly. And that's what we got. We got a great ruling that said, as a matter of common sense, we find that in this case the class action ban just categorically wipes everything away. They didn't turn it on evidence at all. There was nothing about evidence. We didn't meet the Randolph test. We didn't meet the Piet test that came later. We won that day. The Discover Bank rule was categorical. My friend here just referred to how it's manipulable, how it's malleable. And as you had said in your question to him, the Discover Bank case was striking down tons of cases. What we're talking about now is something totally different from Discover Bank. We're saying we only can win where we prove by admissible evidence that it actively bars people from effectively vindicating their rights. It's completely different than Discover Bank.
Just a short rebuttal, if I may.
Could you address those two cases? I mean, there's a lot that he talked about, and we have all these cases. How about, is the Second Circuit opinion in American Express in conflict with the 11th Circuit opinion in Cruz?
No, because the Amex Merchants case is the Second Circuit decision. It is a federal antitrust claim. So it's a pure federal antitrust claim versus the FAA.
Okay, and how about Preston?
I am not familiar with Preston. I need to check that. I don't remember that actually being in the brief. I would need to review that. But I would say this with respect to the issue of vindication of statutory rights. Certainly, Mitsubishi is a federal antitrust claim. Randolph is a federal claim. It's a TILA claim. Amex is a federal antitrust claim. That's where you see vindication of rights coming out. And also, there's a case that we found that actually is not cited in our briefs that's out of the Sixth Circuit that predates Concepcion. It's, if I may.
Well, if it's not in your...
we'll do a filing, but essentially, if you were to look at that case, it all goes back to the same proposition that where you have two federal claims, you have to harmonize them. That's where you get the vindication of statutory claims coming through. And that's not the case here. In Concepcion, Mitsubishi is cited for the proposition, essentially, not of vindication of rights. It's cited for the proposition that we enforce contracts that contain arbitration clauses as written. I mean, because basically there's a federal goal of promoting arbitrations, and we're going to, as a policy, the United States is going to follow it.
Does the record show, though, that there have been no arbitrations against McKenzie Check?
I would say the answer to that is, certainly against this industry, the answer is no. And I just went on the website before our argument. There's about 900 cases that have been administered by AAA. And just by looking at the style of some of those cases, they're against companies that are in the same line of business. Check cashing.
But not against McKenzie.
The thing is, McKenzie has morphed into several different companies, Your Honor, and I don't want to say McKenzie as a named, but I believe as a corporate entity, the answer would be yes, because the name of the company has changed and it's been acquired. But I don't want to speak out of turn because that's really not in the record. But if you were to look at the AAA very clearly requires that if you have an arbitration clause and it's going to be administered by AAA, there is no confidentiality. That's one of the requirements of AAA for administering any of the claims. They list them all and they're posted. So there's no secrecy involved there. And you will see that there are check cashing and check advance companies being sued in that mix as well. On Amex, I have one more point, if I could, on Amex. There is, again, I checked this. It's good as of 2 or 3 days ago. There is an en banc motion pending in Amex that the Second Circuit has not yet ruled on, and I want to make sure that the court was aware of that. And the cost of arbitration, that issue came up to $1 million. Obviously, under this clause, McKenzie is advancing the whole cost of getting the arbitration going. That's not an issue. If there are any further questions, thank you very much for your time.
We thank you both for your argument. We'll now move to the final case on today's docket, Board of Trustees of the Internal Improvement Trust Fund versus American Educational Enterprises.
May it please the Court. Paul Morris on behalf of the petitioner, the Board of Trustees of the Internal Improvement Trust Fund. The Board is seeking review of the decision of the 3rd District Court of Appeal granting American's petition for a writ of common law certiorari. The trial judge in this case had entered a pretrial order directing American essentially to update its financial discovery that had already been provided to the Board.
With regard to that, Mr. Morris, could you outline for us, we're looking at a case where facially, at quick glance, it would seem to be the damages would be the difference between what I had to pay for it and what it's worth, and how all of the financial records are used or how they become relevant in our discussion to begin with. Well, could you address that?
Yes, Your Honor. Well, American is claiming that it was defrauded into bidding too much for this property. And American claims that the bidding package was misleading and that an appraisal was withheld from them and that there were fraudulent misrepresentations. But it must also be kept in mind that American made an unsolicited offer for this property even before the bidding package in the amount of $4 million. So the question for the Board in defending against the complaint is how did the college or American, its successor in interest, come up with the unsolicited offer price of $4 million and eventually the successful bidding price of $4,025,000. And our submission is that American didn't make a mistake in its unsolicited offer as it's claiming in its count for reformation, and it wasn't defrauded, but rather it is a sophisticated business entity that was searching for the appropriate site to have the most amount of success in its business and found this, and had factored into what it would pay its projected budgets, its projected earnings, the increased enrollments that would result if they were to locate to this property, which is...
So you're saying then that the financial information is inherently interwoven with the business operations and how this property was factored into that, and indicates that there's no fraudulent behavior, that there's independent, and this all shows it.
That is correct, Your Honor.
Okay, well, that's fine. Don't waste all your time on that.
And that's as further corroboration of that, there was only one other bidder.
I'm still lost. Could you expand on that, how that would show that? How would the tax returns, the financial statements, and all the information requested actually demonstrate that they made some kind of sound bid for that property? How did that connect?
Because the reason why they and their competitor came up with a $4 million or more price for this property is because what it would represent to them in future profits, increased enrollments, high visibility, all of that entered into their decision, both bidders, to bid $4 million or more for this property.
So what I'm making my tax return and what my financial statements show, somehow, how does that correlate to what I think a piece of property is worth?
Because we want to prove that indeed, not only did that factor into their decision to reach this sort of offer, but it turned out to be correct. And the financial information will support those defenses. It will assist our experts in determining if this was a fair and just price.
I hear your conclusion, but I don't see how you get there.
Well, one of the causes of action here is reformation. That's a cause of action in equity. One of the issues for the trial judge is what is a fair and equitable price for this property? Should it be adjusted upward, downward, or is it a fair price that was paid for it? The profits, the earnings, the enrollments, the highest and best use of this property for this type of business, that should all be discoverable. And the trial judge said it is. And in addition to that, the parties had entered into a confidentiality agreement for the initial disclosure. This same type of financial information has already been disclosed to the board.
So
this is just an update.
Did the judge, though, because that was the financial information from the bank, did the judge, in ordering its production, order that it be produced under a confidentiality agreement?
Well, first, the parties both voluntarily entered into a confidentiality agreement, and that was submitted to the judge And the judge entered an order approving the agreement.
Was there ever a request for an in-camera inspection? Because, I sort of, where Justice Polston is I'm kind of trying to figure out how documents from up through 2008, 2007 would pertain to whether your client failed to give a particular financial appraisal that they should have given them. I mean, it seems that there's some harassment here in this trying to get this financial information.
Well, that, of course, is from Americans' point of view.
Well,
but from the board's point of view, this is all relevant to defenses, and especially the reformation count.
But we're here on to whether there was an appropriate cert being granted on the basis not just of overbreath, but as to whether this was confidential financial information that would not ordinarily be presented. I mean, is this the type of thing that's public information? You're, I guess by saying it's confidential, you're agreeing that it is not ordinarily out in the public domain.
We've agreed, and this is one of the reasons why common law cert did not lie in this case. There are measures at the trial court level that protect this information and keep it confidential. We're not a competitor with these colleges. We're not in the same business. This information doesn't rise to the level of trade secrets or privileges.
Would this information ultimately become a public record if it's in the hands of the Board of Trustees of the Internal Improvement Trust Fund?
That depends on what measures are sought by American at the trial court level. If they wanted or want to submit anything for in-camera inspection, they have those measures available to them. If they want to keep it out of the public record, they can do all that. But they made just a blanket assertion to the Third District that the Third District has jurisdiction to review this without any of those other measures being pursued. And we don't really even get to the merits unless American can show the Third District or this court irreparable harm, the condition precedent jurisdictional requirement to common law cert.
Going back to the reason, though, the financial information, it's your position that the financial information demonstrates they did not rely upon the other documents, that their financial information shows that they had independent judgment that was exercised, so they can't sue you for whatever.
That's exactly correct. And the most dramatic support for that proposition, Your Honor, is their $4 million unsolicited unsolicited offer before the bidding process was even underway. How did they come up with that number?
But that's not relevant to these documents, because this is all about records for years later. I'm not right?
Yeah, that is correct. And those documents...
But you're relying on those just to show that they went through, if I understand what you're saying, that they went through a process to calculate the profitability of acquiring this site, and it turned out to be quite profitable for them, or you believe that the records will show that it's profitable, and that kind of supports your...
That's correct, and we believe that'll support the defense that they factored into their purchase price. But
I guess I'm still having trouble I can understand that if they had done separate projections before they made the bid, that would be discoverable. But the fact that even at $4 million it proved to be profitable doesn't establish, that's different than your argument that they had other independent appraisals.
Well, Your Honor, we're in pre-trial discovery here. We're trying to establish those defenses.
But you agree that we're not just talking about business records. When we talk about financial information, we are talking about something that we've recognized in cases. We have a right of privacy in the Florida Constitution, and sensitive financial information is within that rubric of privacy protection. Correct?
Arguably applicable to natural persons. We're dealing with a business here, but even assuming this business has a privacy interest in these documents, that doesn't mean that the Third District had jurisdiction to review this claim. There has to be a showing of irreparable harm. There has to be showing that the confidentiality agreement measures that are not just available but have been already invoked as to the first disclosure don't apply here, but they do. This is no different from the financial information this court addressed in Martin Johnson. This is no different from the financial information this court addressed in the Beecher case, wherein this court approved Judge Klein's analysis in Eberhardt. That analysis directly applies here.
Well, if this were totally irrelevant, that this were a personal injury claim before judgment and attempts to get financial worth.
If there were showing...
I'm just saying, saying that kind of case, then cert would be available to stop the production of documents that are not yet relevant.
That would certainly be a different type of case.
Well, that's what I'm trying to understand here.
Exactly.
That this is not in the nature of damages or what they're worth for damages. This goes directly to the heart of their underlying responsibility or liability claim and your defense to it.
That is exactly right. And that's the analysis...
I'm not sure that you've explained that to everyone's satisfaction with regard to what does this show, years later? Why years later for this financial? If they used it before in projections, maybe one thing, but why 2 or 3, 4, whatever years later?
Because the reason why they came up with this price was they were looking those years in the future.
And is that to show that actually happened, that they made the same profits that they projected before, that it actually happened?
Well, that it either did happen or didn't. It's either going to bolster our defense or undermine our defense.
Okay.
But regardless of how it turns out, that doesn't mean it isn't discoverable. It answers the fraud directly, and it answers the reformation count directly, but it also supports our defenses to this claim of fraud.
And this was the argument that you made to the trial judge who said these were discoverable. You made the argument that these were pertinent to which of your defenses?
The argument was made that these were pertinent to our defenses. It was a general argument, but the trial judge understood it and agreed and ordered what is essentially, I repeat, an update of financial information that has already been disclosed to us. The fact that it's already been disclosed and subject to a confidentiality agreement means that common law cert does not apply at all. It can't. The third district could not possibly have had jurisdiction here.
This, if I understand it correctly, and correct me if I'm wrong, the materials at issue that this case is about now were not subject directly to the prior confidentiality agreement that covered documents that came from Citibank, correct?
Or maybe. If it isn't...
Well, it's not by... That agreement by express terms does not cover this, does it?
Correct. But presumptively, we're operating under the same...
But let me ask you this. In the trial court proceedings, when you all were litigating this issue that's come up to us, was the issue of a confidentiality agreement discussed at all? Did you raise it? Did opposing counsel raise it? That just wasn't, or was that not part of the mix?
It was raised at the hearing, and the board said we're governed by the confidentiality agreement. There was no objection by the board to keep these items under the same protection as the initial items that were disclosed.
So
that's not an issue.
Position that you're going to follow the confidentiality requirements that are in that agreement. Essentially, you agree to this extension to these documents.
Of course we do.
And that's
of course
on the record.
We would.
That's on the record in the trial court.
In the trial court at the hearing, we operated under the assumption that confidential...
I'm not asking about the assumption you operated under. I'm asking what the record shows. And if I'm not communicating that, I want to know what I can go back there and see about the confidentiality agreement. If you'll tell me.
You mean what the board's... I'm sorry, Your Honor. What the board's position was with regard to the confidentiality agreement, or what it says? Our position is we're covered by it, and if we aren't, we would be.
Was that said in the trial court? That's what his question is. Did you put on the record in the trial court that the confidentiality agreement covers these documents?
Yes. Yes, we did.
Was there a transcript of the hearing?
Yes, there is.
Okay.
But American is arguing that is not the case because it's turning to the exact wording of that confidentiality agreement and is arguing before this court that it does not apply no matter what the board said.
Well, let's see. The bottom line is that if this was simply, we're up here on that if the only issue is should it be held confidential in a confidentiality agreement and or subject to an in-camera inspection, was that asked of American when you asked for the production? Did they say, but if you produce it, we want it to be produced?
American did not request that.
Let me see if I can get back to the relevance and the breadth of this requested information. FNC actually closed on the property in 2001, right?
Correct.
So to the extent that you're requesting financial information that would be since then and perhaps immediately before, it would, I guess, tend to show the income, it would include income of the property, so that then you could look at that and evaluate from an appraisal standpoint the valuation of the property based on its performance of income.
That's true.
Is that why you had it? Is that why you asked for it?
Well, we're mostly looking at it in terms of the business versus the real property.
Did you argue that to the Third DCA or trial court?
Yes. Yes, and yes. And
no specifics?
Yes.
Because I was missing that from our discussion earlier today, and I was wondering if you told anybody else that.
Yes, we did, Your Honor.
Okay.
Yes, we did. And the Third District rejected that. It didn't address all of the arguments we had. It primarily viewed this case from the point of view of American, as opposed to the board's defenses, and as opposed to the board's argument that American really has no grounds for common law cert here, because we already have the bulk of this information, and that its claim of overbreadth simply is without support, because in many respects what the trial judge ordered in the updated discovery covers a smaller time, a smaller scope than the years that have already been disclosed to us in financial information. So our primary objection and our primary claim here, which was the primary claim before the Third District, is that court below had no jurisdiction under Martin Johnson, under Jay versus Saxon, under Eberhardt, all those cases, because it had to reach the jurisdictional question first, which is, where is the irreparable harm that American will suffer if this updated discovery is disclosed and if there is a confidentiality agreement available as one of the measures?
And overbreadth is not a basis for certiorari.
That's correct. Overbreadth alone, irrelevance alone, even privacy claims alone, without more, are not a basis for invoking the jurisdiction of a district court of appeal. And that is really the heart of our argument, is the merits should never be reached. They can't be unless those conditions precedent to invoking the jurisdiction of the DCA are first demonstrated by American. They did not. And an examination of the Third District opinion shows that it is devoid of any discussion of how American can show or did show irreparable harm, because it cannot.
And that's based on the fact that you have the confidentiality agreement. Is that why there's no irreparable harm?
That is a big part of it, Your Honor.
What's the other part?
That the bulk of the information has already been disclosed to us throughout a very long time period, even longer than that which the trial court ordered updated.
And you have to say that it's discoverable anyway.
And it is discoverable anyway for our defenses.
The irreparable harm is disclosing something that you do not have an obligation to disclose.
That is correct, Your Honor.
So, I mean, that's where we are with this. Okay.
Correct. Thank you.
Good morning. Barbara Viniegra on behalf of American Educational Enterprises, LLC. If I may correct a number of the factual recitations here, we have to remember here that we had a 5-minute motion calendar at the trial court. There was absolutely no in-camera inspection, no balance.
Did you ask for that on the record?
We did, and actually opposing counsel.
Okay, so then one of you can't be correct then. So.
Well, one of us obviously can't be correct. Right. And even opposing counsel on the record, and it's part of the record that was provided to the Third District Court of Appeal, stated, Your Honor, we believe that this may require an evidentiary hearing unless Your Honor wishes to rule just on the arguments of counsel. We had no opportunity to present any evidence. The confidentiality agreement aspect was brought up within those 5 minutes, but nothing was discussed whether the new production would be covered by that confidentiality agreement.
Did your party ask on the record for that?
Did we ask for the record for, I'm sorry?
On the record, did your side ask for some clarification of the confidentiality, say, we want this on the record.
No, we objected based on our privacy rights and, of course, irrelevancy and overbreadth. But we have always argued irrelevancy.
You argued this not on any of these other, but you argued on that these records aren't relevant.
And that it violates our privacy rights. And if we look
at... so relevancy, privacy, those are the two.
Right. Relevancy and privacy, and obviously
that's not what the Third District ruled on overbreadth. And do you agree that overbreadth is just in of itself is not a basis for certiorari review?
Overbreadth on its own, yes, I would have to agree. However, overbreadth or overbroad production of financial documents having no connection to the issues of the case does constitute...
But that's not that's not an overbreadth basis. That's based upon the information being irrelevant.
It's a combination of both because
I think you're playing with semantics when you get into that, because the cases are legion saying just overbreadth, because you could strike and say, okay, overbreadth, well then you're going to have to produce them anyway.
If I understand what you're stating correctly, yes, I agree that overbreadth alone is not
enough.
Right, but semantics, that's what we have with the president.
That's not semantics when a court uses that as a basis for its acting. When a court says this is what we hold, and that's not sufficient, that other argument, maybe they should have used your other argument, and maybe that is or is not a correct basis, but the law of jurisdiction, this is going to have ramifications far beyond just your one case, and it wasn't based just upon the financial records.
It was not, but if we do look at the overwhelming district courts of appeal do hold that overbroad discovery with no connection to the issues in the case constitutes a departure of the essential requirements of the law. And that's what the third district...
But this notion that it's got no connection with the issues in the case, I'm struggling with that now.
Well, there's no connection...
I don't know what would be admissible evidence on these claims. So what's your reformation claim? You've got a claim for reformation of this real estate transaction, right?
Yes, reformation of the contract.
What's the basis for that?
Well, we want to reform the price of the contract, the difference between what was paid and the market value of the property at the time it was purchased. And if we look at the time period here, it is an extremely short period of time. This unsolicited offer was on April 2nd, 2001, and by June 30th, 2001, there's a closing on the property. We submitted financials to Citibank that included our client's financials from 1998 to about approximately in projected budgets until 2004. Arguably, those are relevant. We at all times have objected on privacy, but in the spirit of cooperation, at that point, yes, we submitted it to Citibank. So arguably, there might be some relevance or discoverable information from this.
Did you submit to someone projections on the use of this property? Is that what you're saying?
We had to the Citibank.
On how it's going to perform.
We had to obtain financing.
There were records that were somebody sat down and figured a pen to paper or computer as to what will our financials look like if we buy this property.
We had to, because if not, Citibank wouldn't provide us with financing.
And so then these next documents are to determine whether those were realized. Is that what this is?
Not in our opinion. We feel that at this point.
But try to look at it. I mean, again, we're not here about make a determination of relevancy. We're looking at a discovery issue.
Yes. And
whether this is somehow confidential information that is so far outside the bounds of what's proper that they're not entitled to even look at it to see if it might lead to admissible evidence. Well, what I don't... If you've submitted those numbers and those projections, it seems like that these other numbers that show what actually happened are connected to that and a part of this picture, and if you and are somehow could potentially be relevant to your claim for reformation, that somehow you got railroaded here. I guess you just didn't know what you were doing, your client, and were railroaded by the trustees of the Internal Improvement Trust Fund. But if you did real well, it seems like that could be perhaps relevant to some sort of equitable defense they would raise. Reformation's an equitable proceeding, right?
Yes, it is, but we are, by the law, we're only entitled to the difference in damages of what we paid and the market value at the time of the property.
But I think the issue is this isn't going, and now I'm saying it's, and I didn't get it originally, it's not going to the damages. It's going to whether you are really railroaded is sort of what I'm hearing this morning. And in that regard, there was a third-party subpoena to Citibank, correct?
Yes.
Did you object to that?
Yes, we did.
And those records were produced under a confidentiality agreement?
They were produced under a confidentiality.
So you didn't go and seek cert on that?
On what grounds? No, we had no grounds.
Well, because it's financial information. Why should they have financial information? And the same thing that you're arguing now. And I think the problem of what's happening here is that if this is not a competitor who's trying to find out this financial stuff to harass you, it seems that whether it's a slender read, it's a read of connecting some of the financial information that's already been produced and saying, we want to see it from your side. If you're protected by, let's assume that the error is that this should be subject to the same confidentiality agreement that that govern the Citibank records, where is the harm for cert review? In other words, if we agree with you that it just can't be produced and have it in the public record, that it's financial information, and they've conceded here this morning that they're more than fine to have this be subject to the same confidentiality agreement, why, and we don't really know that it might not lead to discoverable information, why shouldn't it be produced but under a confidentiality agreement?
Because it is our position that at this time it's just harassing. If we look at the confidentiality agreement, it is specific to the Citibank records.
I understand that you may have been in your rights to file the cert. We're just concerned because the cert opinion says it was overbroad. And we've got to be very careful because discovery in this state occurs all the time, and cert is a limited remedy. So it's a question of if it's totally irrelevant and totally overbroad and totally harassing, that's one thing. But if it's marginally related, but it should have been protected by confidentiality agreement, then you go, we have a case that says, no, overbreadth is not enough, but it was financial, and to produce it without a confidentiality agreement may have resulted in irreparable harm. I mean, what's wrong with that? Not that you're not rightly here, but that that's the compromise.
Well, where do you draw the line then? And the bottom line is that if the financial information is relevant, the law requires that it is producible, whether it's the Supreme Court standard or...
But that it may lead to the discovery. So anything up through what year would you say any of this, because it is all... There's Americans' tax returns for 2001 and 2 and 2005 to 7. Not sure why they didn't ask for. Why didn't they ask for 2003 and 4? Had those?
Because they already have it. Everything from 98 to 2004 has been produced pursuant to that confidentiality agreement. And I'd like to point out that we never purchased a business from the state. We purchased a property.
What did you do with the property?
Well, it was a hospital. It's the property owned by the state that used to be Glen Bay Hospital. We converted the property into an educational institution. There had to be a lot of money spent in order to convert that into an educational institution.
So the information requested is going to show the financial results of the operation of the property, right?
The financial results of the business, not of the property. And if we look at the appraisals...
Was the property not part of the business, so you can't tell? It's a school, isn't it?
Absolutely.
And you use the school to teach people things.
Absolutely.
And people paid money to go to that school.
Absolutely.
And then that money goes into the coffers of the school. And from that, they take expenses and deductions, and that'll show the operation of that business. You're an education business?
Yes, my client is.
Okay, and would be that any other properties or just this property that you operate?
It's my understanding that it's just this property for this particular school.
That's all that they do, is operate this property as their business.
But as we mentioned...
Is that correct?
Yes.
Okay.
But as we specified in our petition to the appellate court, and as the appellate court stated, there is a difference. Had we bought a property from the state, then arguably our future financials would have been taken into account, because that's the difference between valuing a property and valuing a business. We didn't buy both things from. Let's suppose that property would have been.
All that comes. Those are pieces of the puzzle that an appraiser is going to use to try to figure out the valuation of property on some kind of income basis. I mean, they have to know certain basic information to figure that out. So why is it not discoverable?
Because we have to look at the valuation and at the time of the purchase. Here, the appraisals used the income method, but the income method based on what the rentals of the comparable, rental properties. They were office buildings that they were using as comparables. Had the appraisal used comparable colleges and future income of the colleges, then I would have to agree that yes, it would be relevant. But here, we're looking at appraisals that used the income method for rental properties. We didn't buy a rental property. In fact, we had to spend money, gut the property.
But all of this business about what's relevant and not relevant, that's something that really has to be determined in the context of the specific cases that's being litigated. Here, we're looking at a much broader question about what could lead to potentially relevant information. And I'm just having a hard time understanding how this isn't, particularly in light of the fact that they already have this other information, and in the nature of your equitable claims,
Our equitable claims, there's nothing that we're going to be able to get or establish beyond what the law entitles us to get as damages. This case started in 2002. Almost 10 years later, in September, it'll be 10 years later, we have no punitive damages claims that will be asserted. And there's absolutely, they're trying to get is discovery and aid of execution. There has to be a limit to what you're entitled to get. The rules require that the discovery be relevant. And obviously it is our position that there's nothing else that's relevant. We've already given you more than what you need to get relevant documents.
Well, I think you're going to find in your career of litigation that appraisals have like 3 different methods of approaching the property for valuations, and that income approach and highest and best use and a lot of different concepts go into that. This is not a personal injury case that falls into a compensatory damages, punitive damages. That's what seems to be you all are talking past one another with regard to that. And as the Chief has indicated, the reformation, you have to show equitable basis for that remedy. And if I've got a client A who has calculated all this out, this property is worth $10 million, but I can get it for $4 million, and that's what all my numbers and financial projections are, how can I go back and get reformation from somebody and not only do my projections show it, but my performance shows it? That's where this discussion, you're missing one another.
But the law doesn't permit me to do that. I can only get the difference between what I paid and the market value at the time of the purchase.
I think we're going back to what damages are and whether you can establish a cause of action. And when Justice Lewis and Justice Kennedy are talking about the cause of action of reformation, which is equitable, some of that information may be relevant to as a defense to your claim. And that's why, not as to what you can recover, but whether you can recover it all.
Okay. Well, we would ask that the court approve and affirm the lower court's decision, because the district court here did not abuse its discretion in granting cert review. And they also applied the correct standard because it necessarily found irreparable harm that could not be cured on appeal. They chose to focus on the departure of the essential requirements of the law, and that's what they did, in their opinion. If we look at all the cases, there is absolutely no conflict between this court's decision and Martin Johnson or any of the court's decision on pretrial discovery and any of the district court decisions on certiorari jurisdiction of pretrial discovery, and ask that this court affirm the lower court. Thank you.
We have nothing further, Your Honors, unless there are any further questions. Thank you.
We thank you both for your argument. That's the final case on our docket today. Court is now adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.